Welcome to Looking at Legal Stuff. Today we have 7 hearings and a trial with a couple where Mom was ordered, last January, to have a mental health assessment and share documents with Dad in order to create an initial parenting plan. Mom drags her feet all year and has a million excuses why she isn't doing what was ordered. Now it's December and the judge has had enough of her antics. Let's watch.
All right. Any other quick matters, setovers, strikes?
I was going to see if we could do a continuance for Anderson and Erickson. I was late serving because I'm not represented. And I had to get help through Northwest Justice, the women's shelter, along with having a baby and my toddler. I was late and I feel really bad about that. I wasn't sure how to ask.
That's okay. Ms. Winkles, I see you here this afternoon. You're representing Mr. Anderson in this matter.
Yes, Your Honor, and I would ask that it not be continued. Ms. Erickson, we have, between my client, he has separate cases with her as well. She was able to file a petition in those cases, which meant she chose to do that without answer B. So she's self-represented in both and chose to put in 20 pages into one and none in the other. I would ask that this go forward today. She's had plenty of time. We actually gave additional time. We've been here before. We're here on a motion to compel next week. We were here last week. At some point, the delays need to stop. So I ask that we go forward. I don't mind if she argues something that's not written down. I would just rather get a temporary parenting plan. My client hasn't seen his child since she was born. The GAL report is in. So I don't think there's anything that limits us, especially if she's able to.
All right. Any response to that, Ms. Erickson?
I have a lot to say to that, but I'm not sure if it would be appropriate or not. But the whole motion to compel thing was on because of her behalf, because she didn't send me the right paperwork. So I wasn't saying that I was supposed to call. It said the petitioner was supposed to call and it wasn't me. So that really wasn't on me. But I was just trying to be nice for the other side to read what I had sent. I'm not being represented. I wish I could be. I've been looking. I don't have the money to do it. I have 2 kids at home all by myself. I've been trying to get everything done that I can, and I tried to get it all turned in on Friday. I'm very sorry, and I'm not coming up with excuses or anything. I'm being honest.
All right. I understand both sides and wanting some resolution. We're on for next week, the 9th. I'm going to add this onto the 9th. So I'm going to give you 1 week to submit something. If you don't have anything submitted, then we're going to move forward.
Well,
regardless. I'm talking. Don't interrupt me when I'm talking. Sorry. Okay, Ms. Erickson, okay. That's not a good way to start off here. So if you submit something, great. If you don't, we're moving forward regardless. Is that fair?
Yes, I'm sorry.
All right. We'll see you on the 9th at 1 o'clock.
Thank you.
Thank you.
All right, next is Aaron Anderson and Brittany Erickson.
That matter is ready, Your Honor.
All right, and is Brittany Erickson here? Nobody is responding, so I've got a presentation of order, which I may not be able to do unless it's agreed to, but also a review hearing. So Ms. Winkles, why don't you bring me up to date?
Yeah, so I doubt you'll be able to do the presentation of the order. It would be a temporary order with a parenting plan and also a compel hearing. This is the review for the compel. Okay. And a review of the hair follicle. The hair follicle was done by both parties. We can set that for when the Judge Fassett gets back. But the compel has still not been handled. And so I would ask for a second order because the original one had, in any event, that's the oral order of the court that today we were supposed to have those documents by today. I've not received them. I suppose if I don't receive them by 5 p.m., I can wait and give you the order tomorrow. But in any event, I've received absolutely nothing. And there is a protective order that we agreed to at the last hearing that's in there. Still have not received a single document. So I'd ask that the second compel be signed by Your Honor.
All right. I did see that there was an agreement to a protection order or protective order relating to those documents. All right. Why don't you wait till 5 today? If you don't receive anything, then present an order to me tomorrow and I will take care of it.
Sounds good. Thank you, Your Honor.
All right. Thank you.
So can we set the other hearing over? I'm not sure when Judge Bassett's back.
Next week is closed, so we'll have to go to June 6th.
Fine.
So Anderson and Erickson will be put over to June 6th.
Thank you, Your Honor.
Looks like Anderson and Erickson. 2330001508.
And that matter's ready, Your Honor. We're here on presentation of the family law order and the parenting plan. They were provided to the court on May 22nd and provided to opposing party at that time.
Your Honor, Scott Roberts for Miss Erickson. I was just retained this morning and I reached out to Miss Winkle's office. We're getting a notice of appearance prepared today. And I have no objection to the hearing going forward, given that I was not present in the prior hearing.
Okay. I appreciate that. Thank you, Mr. Roberts. So Miss Winkles, what I have is a temporary family law order and parenting plan. Is that correct?
That's correct, yes. And Your Honor had ruled that the GAL, essentially what the GAL said in the parenting plan was to be instituted. And that's what I did. I just kind of took the language out. I think I did change one sentence around just for formality's sake, for, you know, so it read a little bit better, but other than that, it should be almost identical to what the GAL stated.
All right. I will sign off on these orders. I did review them before court.
All right.
Anything
you.
else we need to do on this matter today?
No, Your Honor. Thank you very much.
All right. Thank you both.
Thank you.
Anderson and Erickson, 2330001508.
That matter's ready, Your Honor.
Sorry for the delay, folks.
That's all right.
All right, we're on for pretrial. Oh, we're just on for pretrial.
No, we're on for a motion for contempt.
I don't have a contempt. I have pretrial management.
Oh, I thought we were on the
Contempt.
motion for contempt. Is that next week then?
I have
I have
a
it
show
next
cause
week.
contempt for 8:15.
Oh.
If you all
Had I
are,
known that, I would have just asked us to move that one to the other.
well,
I got them backwards.
are you, Mr. Roberts, did you think we were on for contempt as well?
No, I thought we were on for contempt next week.
Okay.
And I think you told me that, and I think I had them backwards in my mind. Which
I
is
feel awful making you guys wait this long then.
I
I'm
should have
sorry.
piped up and I apologize too. I was just letting the court to go in the order and I didn't know if Miss Winkles had somewhere else to be. So I'm sorry to both of you.
Oh, no, I'm
No, it's, we're all sorry. Well, as far as pretrial, since we'll be here next week, any issues, discovery issues, both parties ready to proceed at this point with readiness that I show is next. I have readiness on the 22nd and trial slated the week of the 28th of this month.
And I'm fine with that. I mean, I didn't get everything I wanted in the last discovery, but I think just setting this, getting this on for a trial, I think just having testimony will get everything out anyway. I don't think there's any documents that I'm missing per se. So I'm ready. I think we've even done an ER 904 already.
Mr. Roberts?
I think that's fine. I came onto the case fairly late, but I think given the circumstances that testimony and what happens between now and then should get us where we need to go. So with that said, we can move to the next date and see you next week.
Okay. Well, I again apologize for keeping you here for 2 hours on a pretrial, but I will see you next week and I'll do my best to call you at the beginning of the docket.
Thank you, Your Honor.
Thank
All
you.
right. Thank you. Have a good afternoon.
You too.
You too.
All right. Ms. Cutter, I don't show anything else. Is there anything else you see we need to address?
No, we've completed the docket.
And Your Honor, I have a quick one for you as well, I believe.
All right, and which case is that?
It's Anderson v. Erickson, 23-3-00015-08. We're here on the, I believe it's the fourth review of the motion to compel answers to discovery to interrogatories.
Is Miss Erickson present? Ellie Anderson, or Ellie Erickson, I'm sorry.
That's the child. That's Brittany Erickson is the
Oh,
respondent.
sorry. Is Brittany Erickson present?
And just so your honor's aware, interrogatories were served on January 12th, quite a long time ago. We had a CR 26I on March 6th. Still, we didn't have compliance. We filed a motion to compel back in March of 2023. Hearing was held April 18th. She was given 3 weeks to comply. She didn't. Attorney fees were given. We had a review on May 9th. Still 117 days had passed, still no answers. We had that review March 9th. She was given an additional 14 days and told that if she did not answer, that she would have, her pleadings would be stricken. She was given a protective order just for her address. She was given till May 23rd for that striking her pleadings from the record. She did not answer. They were stricken on the June 6th compliance order. This is, again, we did another CR 26I conference on June 2nd. She did not attend. She did have new counsel as of June. We did another notice to them. We showed them what the deficient responses were. We sent another motion to compel. It's been 265 days. She's not materially answered. We'd ask for her to be defaulted. The court has tried everything: attorney fees, striking from the record, not able to give testimony, additional time. It's been almost a year. She shows up, she doesn't show up, her counsel shows up. She had counsel for months, and we tried to get discovery and we were unsuccessful.
One of the things that I guess I'm concerned about is that I look at the declaration in support of the initial motion to compel back in March. And I realize that other judicial officers have ruled on this, but I'm being asked to find somebody in default. And I see respondent failed to answer said discovery, and a 26I conference was scheduled. Said date has passed and respondent has failed to attend scheduled CR 26 conference. There's a notice in the file about that. And I don't think that
we did have a conference. We've had 3 CR 26Is where she's not made it to 2 of them. One of them we did have. That's where she asked for the protective order. That was before the May 9th hearing. We agreed to protective order. We came to court. We agreed in court for the protective order. She was given 2 additional weeks to get that back, and she failed. So we have had a CR 26I again when she was with counsel. We did discuss discovery. We were also told that we'd have it back. We sent them out a deficiency letter, and again, nothing. So the first one, we sent a notice of CR 26I. The remainder of those we scheduled. And I have talked to Ms. Erickson. I have talked to her former counsel, Scott Roberts, but nothing ever comes of it.
So you actually had a CR 26 conference?
Yes, we had a CR 26I, and I believe it's in the declaration or it's in the order on this hearing. Bear with me. So she missed the May 24th, but she attended the earlier one.
The other thing is, that was my first concern. I'm also concerned that she's answered the interrogatories at this point, maybe not entirely to your liking.
They're materially deficient. We can't put on a trial. We don't know. She was given a protective order so that I could have the information, but we know nothing about the child's doctors, the child's school, daycare, her drug and alcohol history, her address. Most of those things are missing. Her income, I don't believe she's working, but I'm completely unsure. We did send out the notice. I have spoken to her.
I'm comfortable limiting her to her answers, but I'm not comfortable with the default at this point.
Okay. My concern is that I'm limiting her answers. My concern is she's not even going to show up for the trial. Would Your Honor, is there anything I can do to make Your Honor comfortable? Set this out 2 weeks, and because we already have her pleadings stricken, set this out 2 weeks and do whatever necessary in order to I just want the discovery, to be honest with you, because even if she's defaulted, it doesn't change that I have no idea any of the circumstances of this child's life are hers. I'd be more than willing to set this out, serve her again with it, serve her with a notice of CR 26I, give her the deficiency letter because she has received that through counsel, outlining exactly which questions she needs to answer. I'd rather have that than limiting her answers, to be honest with you.
Your Honor, this is GAL. I also had the same problems getting I've gotten nothing from her I needed except for the limited things in the report. Her attorney reached out to me asking me, and I gave him what I had. He goes, and it wasn't what he needed. So I also have the same problem.
Yeah, I think, at least for me, I think I would need probably a deficiency, a more specific deficiency letter as to, because I've got a large exhibit here, and I have to guess what, or make my own judgment as to what's sufficient and what's not, and it's a pretty extensive document.
Is Exhibit E of the motion, is that not sufficient enough? That was given to her counsel. It lays out exactly which ones are deficient and what she's failed to answer. And that was provided on August 7th.
Okay.
I can also maybe make a table showing the question and the.
That's fine. Let me look at it.
Okay. And just so Your Honor's aware, that was me paring down, taking out at least 50% of the questions that she hadn't answered and just getting to the things I absolutely had to have for trial. The original letter, I believe, is at C or D. It's considerably longer.
So you're proposing sending another deficiency letter and coming back in a couple of weeks? Is that?
Yes. Yeah, at this point, her pleadings have already been stricken. There's nothing she can do at a trial. But really, we still need the information, to make a parenting plan, even if she's completely out of the picture, aside from a default where I just, assume things. We need the information. So I would ask that we come back. I'll send her another deficiency letter. I'll outline exactly what needs to be answered. If Your Honor can give me a drop dead date on a date where I tell her you will be defaulted if it's not, received by such and such date, I would be more than happy to do that.
All right. October 31, I think gives her plenty of time.
And I will email her, mail her, and I'll provide proof of service of the same to the court much earlier than that date.
All right.
All right. Thank you, Your Honor.
Thank you.
About the trial. I just found their trial. I had no idea I had a copy until I stumbled across it hiding in the wrong folder, and I wanted to make sure you got a chance to see it too. This entire 3.5-hour clip is new, and then we pick back up where we left off from the previous video. Sorry I missed it.
Good morning. If we could go on the record in the courtroom, please.
You're on the record, Your Honor.
Thank you very much. We are here in the matter of Aaron Anderson and Brittany Erickson in 23-30001-508. We're set for a half-day trial this morning. I received a rather large trial binder from Mr. Anderson's side. I did not receive anything from Miss Erickson. I don't know, Miss Erickson, if you did submit anything. You're muted.
Sorry about that. I recently actually lost my attorney. He quit, so I have no idea what to do or where to go. I did go to the court hearing over the trial readiness, and I was never called. And I was on there from 11:30 to explain all that, and nobody ever called me up or got me through on the court. Unless I was on the wrong one, I sat there and waited. So I'm confused on everything, because he told me, Scott Roberts told me that he's like, just get me the information you're asking, I'm asking you for, and your job is to take care of your babies and let me handle all this. And so that's what I did. And then he quit after being paid $5,000.
Hold on one second. It looks like the case was called for readiness on the 17th of October at 11:33 a.m.
Yes. And I was on there at 11:30, and nobody, it had me waiting in the waiting room the entire time. And finally, after 20 minutes, I was like, that's a little weird. So I had to made a phone call, and then they kind of sent me all around. And then that's when they told me, the last lady I talked to, she told me that that there was only 2 people in the hearing, so it went pretty quickly, and that it was already done when I was waiting.
Do notice there was a notice of intent to withdraw from Mr. Roberts filed on the 19th of September with an effective date of September 22nd. So it's been well over a month since he's withdrawn from the case.
He didn't let me know until he said that his old boss said that he wasn't allowed to tell me until a day before he was able to leave the office. And he said that his boss at the time said that it was odd, because I was like, well, why couldn't you have told me? And he said that his boss said that he could not tell any of his clients that he was leaving until day of or day before, something like that.
It indicates that he let you know on August 18th that he was going to be withdrawing the next month.
No, he did not. It didn't.
Well, okay, I'm not arguing with you, Miss Erickson.
Okay.
I'm telling you what information I have. He entered a declaration of service on you, as well as Miss Winkles and Miss Langford, that the 18th of August 2023, he notified you, Miss Winkles and Miss Langford, that he would be withdrawing on the 22nd of September. So that's the information that I have. And then his withdrawal was effective on that date.
I can pull up the phone call because he called me on my phone.
That's not going to help me in any way, but Miss Winkles?
Yes, Your Honor. Miss Erickson's been in court on a number of cases. She knows how this process works. She's had counsel. He withdrew. We worked together before. I did not receive any call. But what I can show is a consistent pattern of pushing back and pushing this back further and further. This is the second time we've been set. I'd asked to go forward today. Miss Erickson's can't present any testimony today anyway, considering she never followed through on discovery. We went through 4 different motions to compel. At the last one, Judge Scudder said he was going to default her on the 31st. I still haven't received anything. So she can be here. Her pleadings were stricken. That compel order has already been entered by this court. She was not allowed to present any new testimony on anything that she didn't give us in discovery. There's nothing. So I'm not sure what pushing this back would do any. Essentially, she had years and years to prepare at this point. So I would ask that we go forward. My client has waited long enough in the parentage action and in this action. It's just foot dragging, not received anything, not received collateralized reports, not received any evaluations, anything like that. I feel that today will be quick, but she's had the chance to respond. She could have even called my office anytime since readiness to now. She has not done so.
I do see May 26, 2023, there was a second order compelling answers to petitioner's first set of interrogatories and requests for production. And it does indicate if there is nothing disclosed to, or if there was a failure to provide answers by May 23rd, 2023, and that was the date set by the first motion to compel. And so all the respondents' pleadings were stricken and no evidence can be provided. Or excuse me, no evidence can be presented. So Ms. Erickson, this it appears to me that the writing's kind of been on the wall as far as that part of this goes for at least 5 months at this point, since no discovery was ever provided to Ms. Winkle's office. And that I note is the second order. The first one was entered, looks like earlier in May.
And Your Honor, we actually had a third meeting as well. Your Honor was there, said the same thing as Mr. Nelson's ruling. We just didn't put another order in, but we had that. And then again, Judge Scudder, we haven't put an order in because we said review date he said for today, essentially, but on the 31st, really, even though it's after the trial. And that was for default at that point.
Okay. All right. Well, then let's, based on those previous orders, most recent order from May of 2023 from Commissioner Nelson at the time, I think we should proceed at this point. So I'm going to allow opening statements from either side, and then we'll start with Ms. Winkles in her presentation. So any opening comments?
Yes, Your Honor. This is a case of Mr. Anderson, Miss Erickson. They have a daughter born in 2019 that's 3 years old. My client did not know he had a daughter until recently. The moment he found out he had a daughter, he essentially attempted to do a parentage action. That dragged on and on, attempting to get the child in for genetic testing. A motion for contempt was put forward to the court. Miss Erickson finally complied. The child was his. A little bit of background before that. From 2015 to 2018, the parties had a volatile relationship. Both of them were drug addicts. My client was a drug addict. Miss Erickson was a drug addict. Methamphetamine and heroin were their drugs of choice. They were terrible together. They were toxic. They were mutually abusive. My client absolutely committed domestic violence. Miss Erickson lost 2 children. At some point during this time, she lost her older child to, I believe, the paternal grandmother, I think that one was the baby's father. And then the next child she lost to the paternal grandmother. Miss Erickson has been in and out of dependency. Miss Erickson has been on the same trajectory since that time. There's allegations of mental health issues. There's allegations of drug abuse. Her own mother put a statement into the court in another case stating that she was an opiate addict. Miss Erickson has been asked in no less than 3 different matters to get a mental health evaluation collateralized, to get a drug and alcohol evaluation collateralized. She has failed to do that until today. She still has failed to do that in this case, and that was ordered. What she ended up getting was right before time an uncollateralized SEDS evaluation, which isn't really worth the paper it's written on. Neither Vashti Langford nor my client got to put in any input whatsoever. She was ordered to go and have that changed. She never did. My client, on the other hand, this is one of those times where you have a life and death situation. You're afraid you're going to die and suddenly you change your life. My client went to the hospital and ended up having a growth on his heart. It caused him to completely change his life. He's probably one of 2 success stories I've had in my entire practice of people actually staying off drugs. He has been clean of any and all substances for almost 3 years now. This is a man who was an opiate addict and is not. This is a man who used meth on a daily basis and no longer does. He went from having no job and essentially being, in and out of jail to having his own place in Portland. He has had a job that he's kept for a really long time. He has done everything that you could imagine to stay off drugs. This is not someone that's just trying to tick boxes. This is somebody who's had a DV evaluation with collateral contact and treatment with Olivia Lovely. Those notes are excellent. He's doing well. He's been to rehab. He's been to relapse prevention. He's been to another relapse prevention. He has been to, he's had a thorough mental health evaluation. He's completed all his treatment programs. He's participated in relapse prevention. He's taken parenting classes. He's completed DV and anger management treatment. And he's done that twice, even though he was only ordered to ever do it once. He's consistently provided clean UAs and hair follicles. He's had steady employment, and he has great housing. He has been in reunification therapy with Charlotte Rosen and his daughter, and it's going amazingly well. The one issue is that the child knows 3 different daddies, and the guardian ad litem that will be shown in her testimony. If we look at these 2 people and what essentially the best interests of the child are to be with my client, and that's not to say Ms. Erickson can't be a great mother. It's to say that she has provided no proof that she is stable, that she is not on drugs, and that she's mentally healthy. In fact, it's been the opposite. She has provided absolutely nothing, and yet her participation in this case has been less than stellar. She has failed to give the guardian ad litem any information that the guardian ad litem needs. She has a live-in boyfriend. We know nothing about him. Has refused to give information about her address despite there being a protective order. Her answer to everything is that my client committed DV years ago, and he admits to that, and that's why he went to treatment. He has left her alone. He doesn't want anything to do with her. He wants to build that relationship with his daughter. At first, we were asking for a phased-in approach. We were asking for joint 50-50 custody, which is what Vashti Langford, her recommendations were as well. At this point, though, given that there's significant intransigence by Ms. Erickson, that we don't know if this child is safe, we don't know the mental health status of the mom. She did have another child recently. We know nothing about her drug use or anything of that nature. We would ask that there be a transition period to my client using grandmother. There will be testimony elicited today that Ms. Erickson uses grandmother and grandpa as essentially minor guardians without being minor guardians. And we'd ask that there be a slow phased-in approach over the course of the next 4 weeks so that my client has full custody. Ms. Erickson has supervised visitation 1st and 3rd and 5th weekends until she gets a collateralized SEDS evaluation and gets a collateralized mental health evaluation with a parental risk assessment. We are significantly concerned. And there will be testimony from Charlotte Rosen today about how reunification therapy is going. Hopefully we'll have the other witnesses. I don't see them right now, but they might be in the waiting rooms. And they'll be testifying about my client's treatment and about how well he's done. Thank you.
And so I just want to confirm you do intend to call the GAL in your case?
Yes, I do.
All right. Ms. Erickson, if you want to unmute, if there's any opening statements that you would like to make.
Yeah, there's a lot to be said. I do have issues.
You're muted again.
That's weird. I'm using my dad's phone, sorry. I've been clean and sober for almost 6 years. It'll be 6 years in February. I have done actually 2 hair follicle tests for Mr. Anderson, including a UA for him. That was all of everything, and I passed those. My attorney had everything, all the records and everything. I have nothing. I have no access to it. Sorry, I have my dad here to help me talk.
I have to ask that he not assist you in any way. He can be
Okay.
moral support, but he cannot tell you what to say, or that wouldn't be allowed in a courtroom. And this is mirroring a courtroom.
Okay, no. Okay, but anyway, I did those, no problems, and I can do them again. I did my evaluations, and I had those also. I even had to, it was kind of it was, can't even think of the words, but no, when I got those fixed for the collateration or whatever it's called, for my mental health and everything, it took a little bit because I was talking to so many different people that it all got confused, but that's been done and over with. I honestly was confused. I confused myself. I don't know if it's because of me just having a baby, my hormones, I don't know, but I confused myself because when Vashti told me, because I asked her where I need to get those evaluations done when she came to do her interview thing with me, and I was like, well, Columbia Wellness. And I just thought that was just the only place that you would get them at the time. Because I've thought a lot about that. Because I'm like, well, because it would make no sense, like you said before. But for some reason, with her saying that, in my brain, I thought that they knew that was the only, I don't even know right now. I went through a little bit of postpartum after having the baby. That's why I've been all over the place through these court hearings and taking care of the baby on my own and my toddler. I have no live-in boyfriend. It's just me here with my children and my dog, who is not dead. And because that was mentioned that my dog died, and he's very much alive. And I really don't know what to say, because Scott, he was so helpful and he was able to speak better than I could. And that's why I reached out for an attorney. I have a hard time speaking. I have raised my child all by myself. Aaron has known about her since my pregnancy, and I put in proof of that, but they took all that out because of my emotional I just got emotionally upset and was all over the place during the court hearing. So I screwed myself, basically. But I provided evidence of him knowing about her and him going to jail. And I would reach out to him several times and nothing. Wouldn't receive anything back until a few months later, saying that he found my daughter's shoe at some random guy's house or whatever. It was weird. And I have all those text messages that I submitted, but somehow Mrs. Winkles was able to take all those out and make it look like I didn't submit anything. That's all I'm aware of anyways, because I know I submitted them. I don't want to lose my baby. I've raised her. She, it would be detrimental for her to be taken out of my care. I've raised her. Mr. Anderson actually just tried to hit me with child support when he has even helped not even a dime with mine. And I'm really confused about that, on how he could do that, child support. sent me a letter. And I have not gone after him because of the domestic violence situation and fear of him. I didn't want any kind of lash or anything like that. So they had me on a special spot where they didn't go after him, even though I was getting help through the state around the time when she was born. And about daddies, there's only one daddy that was ever, she's the one that called him daddy. And we don't use the word daddy. Like, I call my dad daddy. So she started calling my dad daddy. So I had to start calling my dad Papa because she was getting confused over that ever since she could talk. And she did start calling my boyfriend Cody daddy because of the baby. And it was all on her own. And I never even pushed that or anything like that because we don't use that word at all. I don't know where the third one's coming from. I don't know if that's meaning for my father. But yeah, I don't know. I've never pushed my daughter on that, and I never will, obviously. I think that she's just really confused because Aaron chose to be out of her life. So all she's used to is Papa, to be honest, while I was working, Papa and Nana.
How old is your newest baby, Miss Erickson?
She will be a year. I can't even believe it. A year next month on the 8th.
Okay.
It's been the whole entire time. I feel like I lost out on my baby, like this whole court thing, because I've been so worried about Ellie. And I found out that I do have PTSD, and I didn't realize that. And I'm getting help through Columbia Wellness, through counseling over that. But I have PTSD over my children that were temporarily taken from me. They were not taken from me. I have my children. My son is with his father, and I can see him whenever I want. And Lexi actually is at school. My father just took her there. So that is not true at all either. The reason why I lost temporary custody was because of them witnessing Mr. Anderson putting his hands on me.
How many children in total do you have in your care on a regular basis?
On a regular basis, I have 3. Plus my fur baby. I always consider Harley as my fur baby.
All right. Okay, thank you very much, Miss Erickson. I appreciate that information.
I thank you.
All right, Miss Winkles, if you want to call your first witness, and I just want you to know there's nobody in the waiting room at this point.
Okay. Hopefully they'll log on soon. I'd like to call Vashti Langford, the GAL, to the stand.
All right. Good morning.
Good morning.
I could have you raise your right hand, please. Do you promise or affirm all the testimony and evidence you're going to present here today is the truth and the whole truth under penalty of perjury?
Yes, I do.
Thank you. And if you could just state your full name for the record.
Vashti Bernice Langford.
Thank you very much. Go ahead, Miss Winkles.
Okay. Miss Langford, how many times have you been appointed to the court as guardian ad litem?
Ooh. I would say over 50, 60 times.
Okay. And you were appointed to this case, correct?
Correct.
And what was the nature of your appointment?
My appointment was to investigate both sides, but on the father's side, and investigate his sobriety, his lifestyle, his housing, his employment. And then on the mom's side, her housing, employment, mental health, and sobriety.
Okay. And did you conduct the evaluation and make a report to the court?
I did.
Okay. And what conclusions did you reach after your evaluation?
I think my conclusion was that Aaron needs to be able to see his daughter. I understand fully and have empathy for Brittany's concerns from the past. I talking to both sides. Aaron was very honest about his past history. Brittany was very honest about her past history. I really understand her fear due to what happened in their relationship then. But I also see the progress that he has made. I see the progress he's even through this course. He's made his home ready for her to come visit and eventually visit and stay with him when possible. He's done the steps with reunification and treatment and not just drug and alcohol treatment, but anger management, relapse prevention. He's shown a healthy lifestyle that he's worked very hard to keep up. And I see that, again, it was a struggle on Miss Eric's side because I was never able, she said that she was getting services. I was never able to confirm those because either I wasn't on not release information or I was just never given the information. Even when I kept calling to check. But talking with her, my concern is some mental health, maybe potentially some untreated mental health. She just said that she just found out she has PTSD. That's a big red flag to some of the things I was seeing, concerns I was seeing. She dwelled on, hyper-focused on the past and was not willing to see what's happened, what changes that he's made, along with the changes she's made with her drug and alcohol issues in the past.
Okay, and you wrote a report for this case, correct?
Correct.
Okay, and is that report what is identified as Exhibit 18 in that big trial binder I gave you?
Yes.
Okay, and Your Honor, that was in an ER 904, so I'd ask that Exhibit 18 be admitted. That's a sealed guardian ad litem report. Oh, you're muted.
I'll admit exhibit number 18.
Okay. In that report, did you suggest that after reunification therapy that the parties move to a 50-50 schedule?
Yes.
Okay. And is it still your belief that the parties should have something akin to a 50-50 schedule?
My concerns now, simply because she stated that she's had an evaluation for mental health and drug and alcohol. I still never received that. Her attorney actually reached out to me asking for anything that I had from her because he did not have anything. The things I've gotten from her are screenshots and pictures of things, and they're cropped, so I can't really tell what they are. They're not actual documents from the agencies that I'm needing the information from. And every time I keep asking, they need to send it to me directly. I've resent my email. I've reached out to them, and I've gotten back just a phone call saying we don't have ROI to release anything to you, or I don't get back anything. My concern is that I don't have the right information to say she should have full custody of her child right now. It's very sporadic. I know that you've had a hard time serving her, the communications. I mean, I've been to these hearings and we just are not getting what we need. So honestly, I can't say it should be 50-50. I'm not sure without the right information. I can't say that now. When my report went in, I was feeling more confident. She was getting things done. We had the hearing. She was going to get an evaluation. She's going to do this. But since the hearing, that's none of those things, at least I have evidence of, has happened.
Okay. And about how many times did you speak to mom?
Verbally about 10 or 15 times, but via text and email over 60 times.
And in those texts and emails that you did, or even over the phone, was there anything that stuck out to you about mom's behavior or her affect?
She always went back to their past relationship and the physical abuse. And again, I totally empathize with that. I understand where she's coming from that. But no matter what I tried to talk about, it always went back there, and why he was so dangerous. And it never, I couldn't progress past that. And on anything I asked about, it would always go back to their past relationship and the abuse.
And did you speak to anyone else aside from Miss Erickson on her behalf?
I spoke with her mother or her father. I had a couple other people, but I spoke to both her older children's fathers. And I believe that's it.
And what did you learn about
Olivia Lovely as well.
Okay. And what did you learn about her older children during your investigation?
Her older child was removed from her home by the father, because the child would come to visit and say that he witnessed the physical abuse and drug use with Brittany and Aaron. So he went and filed for full custody, and he has had him ever since. He was coming to visit Brittany. The father mentioned over the last, since high school, really, so he started high school, the visits have been less. But he's had full custody since 2017.
And was that the case where did you review any guardian ad litem reports from those other cases?
No, he was not able to find the copy that he had, and I could not pull that up.
Okay. And concerning her other child, what did you learn about the other child?
Her other child was also removed, and the biological, the paternal grandmother has custody of her, legal custody of her, guardianship of her. But the father has, since this happened, clean and sober, working, has a job. He has majority custody of her. He does allow her to go to Brittany's, I believe, 3 times a week. So like she mentioned, her father was taking her to school because when she's there, that's the process they have. And when she's with dad takes care of her. But really, grandma has removed, she has a guardianship, but she's allowed dad to step in and be more of a father, and then Brittany has visits.
Okay. And in those cases, was Miss Erickson asked to do drug and alcohol evaluations and mental health evaluations?
I believe so, yes.
Okay. And to the best of your knowledge, did she ever get any of those evaluations?
Not of my knowledge.
Okay. And Miss Erickson, she told you that she was in treatment for mental health. Is that right? Is that what you testified earlier?
She said that she was getting counseling with emergency support shelter. I could not confirm that. They only just said that they were providing services. I tried to get additional information, and I was not approved for that because she would not. That was all I was allowed to know from them. She said that she was getting ideal options for treatment and never received anything on that. I did get some really old screenings, like 2010 screenings, but nothing anything I had, it was, like I said, it's pieces of things, and it was never current. I want to say the last most current thing would have been from 2015 that I saw.
Okay. And so you have no idea if she's had an evaluation for anything at this point?
No, after the last hearing, she was notified to get an evaluation. She contacted me again in August. I asked if she had the evaluation. She said yes. I asked for a copy of mental health and of any of it, and I never received anything.
Okay. And she did provide a UA though, is that correct?
Correct. I believe
And-
2 UAs.
Okay. And, oh, apologies. And was it your understanding that Miss Erickson was on Suboxone treatment at 16 milligrams?
That was what she stated to me, but again, I never saw anything current showing any of that.
Okay. And the hair follicles though, they didn't show anything for buprenorphine or Suboxone, is that correct?
No.
And do you have any concerns about the child being in mother's house at this point?
Oh, only because I'm concerned she has some mental health things, and this is probably triggering other things for her that she probably needs to get help for. And I'm not concerned that she will do anything to the child. I know that she's a lot of support with her mom and her dad. I know that she is living in her home, and when I went and visited, you could very clearly see it was clean. I mean, it was lived in, but it wasn't dirty. You know, her kids had a space, she had a space. I'm just concerned that all of this is probably she probably had things going on already, and this probably is very overwhelming. And I think that she needs to find that balance and support, and maybe allowing Aaron to step in I know it probably is very fearful for her, and she's very terrified of that, but I feel she needs to get some kind of additional mental health support. And I think that having that time to do that and having help with Aaron helping with her child and would probably help her, even though right now she probably doesn't see that at all.
Okay. And did you discover anything about how often she has the child in this case in her care and custody?
For what I know, she has the child all the time. I know that her parents, when she has appointments, try to help with childcare. But from what I understood, they always help her if she needs it, it seems like. But the child, from what I know, was living with her.
Okay. And did you have any concerns about Miss Erickson remaining in this area? Did you have any concerns about Miss Erickson taking the child out of the jurisdiction?
I didn't at first, but I do now. I feel like she's in a fight or flight mode, and I'm a little afraid that might happen. I could be completely wrong, but just the behaviors I've seen via text, email, I'm a little fearful she might take off because she doesn't want Aaron, in fear of the past history with them, that she would take off. Yes.
And at any point, did you speak to Charlotte Rosen or Allison Long about reunification therapy?
I was never given the report from Allison Long. I spoke to Olivia Lovely. I've not spoke to Charlotte.
Okay. And do you, I guess I should say, was Miss Erickson, given the court order? Yeah.
Wait, I just thought about Allison Long. The only conversation with Allison Long that I was given was that mother had refused to provide documentation or release information for me to get me, and I believe your party as well, to get any information. And that was pretty much it.
Okay, so she refused to give information out to you or to me.
Yeah.
And okay. And Miss Long was the initial reunification counselor, correct?
Correct.
And then that never happened, and then it became Charlotte Rosen, correct?
I didn't know that until just recently. So
okay.
I was not given any information.
And while you were in the case, was Miss Erickson compliant with the court orders, and did she help to facilitate the bond between father and child?
No.
Okay, tell me what facts led you to believe that she wasn't facilitating that?
I wasn't getting information that information from her. Yes, I got, and it was pretty much the same information about the abuse and drug use and her fear of the situation. but I never got any evaluation. I never got, I got a couple UAs and hair follicle. I never got any documentation from actual agencies that she said she was working with to support her mental health. I never got, I know that you never got your any information that you needed for her. She stated it was because of the address, but he already had it, which you would have, I know that we all would have taken it out. That wasn't a concern, at least from us. It was almost, it was just argumentative versus just here, let's provide this information so we can work on this together. And I'm not really sure why. Besides, she keeps saying that she's afraid of him, but the information needed is trying to help guide this relationship better in the court for her child. And I'm not sure if she really understood that, if that's the issues she had blocked in the past, just blocks anything that we are trying to do. That's all she wants to revert to when you try to bring up anything.
And did you also spoke to Dad in this case, correct?
Yes.
And about how many times did you speak to Dad?
Verbally about 2 or 3, and via email, text about 20.
Okay. And what did you what stuck out at you about Dad?
That one, he was 100% honest about his past, but he showed progress even before this case. He was showing progress at improving himself. I met with people that people he had me in contact. They were the same. They talked about what his past was, which was not a very good past, and they've witnessed him progress and become a better human. They would say, then I wouldn't be here telling you anything about him in a positive way. And they said they've watched him completely turn around his life, get his life together. Like I said, I saw his apartment. He has a space for her. He's wanting her to come and visit. He doesn't want to rip her from her. He wants her to be safe. He wants to have a relationship with her. He doesn't want to take her away from him. In fact, that's not what his end goal is with this. He wants his child. He now knows he has a child. He wants to be in the child's life. He wants to help support her in any way that he can. I understand. He understands the fear that she has, and he's doing the reunification. He's willing to, if she doesn't want to have contact with him in exchanges, he's willing to make that compromise. It's not about either one of them. It's about him building a relationship with his child.
And during your investigation, did you find has Dad contacted Mom at all in the last year? Did you discover anything about that?
Not that I am aware of.
Okay. And did you find any evidence that Dad is still in active use of any drugs or alcohol?
No.
Okay. And Dad has gone through anger management and domestic violence treatment. Is that correct?
Correct.
And you said you also spoke to Olivia Lovely?
Yes, I did.
Did she have anything to say about Dad?
Yes, she said that he was working. When she met with him, he was progressing and working very well on himself, and was hopeful that this would end in a way that they can both agree on. She had nothing but positive things to say about him, and she understands. She said the same thing I'm saying. She understands the fear that Miss Harrison has from the past, but she sees that he is doing well. He's trying to work at it.
And did Father have any criminal history or domestic violence history since he's been sober? Did you find any evidence of that?
No, I did not.
Okay. And did Father seem well adjusted to you?
Yes.
Okay. And did his lifestyle provide a stable environment for the child?
Yes.
Okay. And do you believe Dad would have the capacity to continue to support a relationship between child and mother?
Oh, yes. Yeah.
Okay. And what's your opinion about the father's capacity to care for the child?
I think that he hasn't had a child live with him, so I'm grateful he's doing the reunification first. And I did talk to him about some parenting classes as well. And I think that he would need support at first, but I mean, I think he'll get used to it. He's willing to step in and help and be there for his child. He wants to do that. I think that he, like I said, doing some parenting classes and joining some parent groups, even in his areas. I know he's not in local, he's in Portland. And there's a lot of parenting options and groups there that can help support him in that.
Okay. And what would your recommendations on parenting at this point? If we just look at mom first, would you have any limitations on her and your recommendations?
Based off of not my report recommendations, but right now recommendations.
Right now, yeah.
Right now, I think that mom needs to show and go through mental health supports. I think that right now she needs supports, if that's with her mom and dad helping, to help with that reunification transition, because I think that's going to be very difficult on her when and if that happens. I think that she also probably could take some parenting classes as well, but I think that 50-50, I would almost say 75-25, and 75 being dad, but that's not immediate. That's not immediate at all. But
what would you said it's not immediate. How would you see that going?
I would see grandma and grandpa helping that transition with dad. And if that's being where she is with them for the other 25% of that 50, to help with that transition, that could be, if that's them doing the going to the reunifications with the child instead of Brittany, because I know that's really hard on her as well. I think that I think that maybe her responses to the situation is probably also not helping with any of the reunification process.
And how many weeks longer? So they've been in reunification for about a month now. And I believe they were going to start moving to overnights. How many, what length of reunification before this transition period would you recommend?
They've been going for a month and a half. Did you just say?
I believe it's about a month and a half.
Okay.
Yeah.
I think that, I don't even want to recommend. I think that's more of a Charlotte question. But I think that the whole transition, though, I mean, it's 6 months. It's a process. And I think that if mom in that 6 month, moms can show she's in mental health, she's taking care of herself, she's showing, like, I have no documents. She keeps saying she's had evaluations. I have nothing to prove that, and no agencies have provided me with that. If she can do these things within that 6 month phase, maybe coming back in and looking back at a 50-50. So, but it's a process. I don't see overnight stays in a week. I see maybe going to a park visit within a couple of weeks. I mean, month and a half, that's a long time. And I know it's probably not an easy process for mom and daughter when they are doing that. So maybe having mom not be a part of that process and maybe grandparents step it in might help a little bit.
And do you have any current fears of the child's health, safety, or welfare in the custody of mom after this hearing?
No, I don't think she's going to do anything to harm her child. No. I think that my concern is her mental health, and I know that her parents are probably there to help her and support her. I just, the only fear I have is that she doesn't take that help because she doesn't trust anyone right now. And then my concerns would be for the well-being of the child and her safety.
Okay. I have no further questions, Your Honor.
Thank you. Ms. Harrison, do you have any questions that you would like to ask Ms. Langford?
I don't really, not questions. I do have copies because my attorney, well, he was my attorney. He had me go to Columbia Wellness, and I have those copies of the evaluations. He was the one that was supposed to.
Your Honor, I'm going to object. the discovery would have been the perfect setting to deliver those. Anything that she's not allowed to present evidence that wasn't given in discovery, never received those.
So I'm going to just ask again, if there's any questions that you have of Miss Langford, this would be an opportunity to ask those.
I can't think right now. I don't think so. Thank you for your work. That's it.
All right. Thank you. Thank you, Miss Langford. And I'm assuming, Miss Winkles, we can excuse Miss Langford at this time.
We can, Your Honor.
All right. Thank you.
Thank
You
you,
are
Your
free to
Honor.
log out if you'd like.
Thank you.
Still no one in the waiting room, Miss Winkles.
Yeah, there should be 5 people there and nobody's there. I'm wondering if nobody thought it was going to go forward today. I'm having my staff call, so I will go ahead and call Mr. Anderson to
Right.
the stand.
Mr. Anderson, good morning. If I could have you raise your right hand. Do you promise to affirm all the testimony or evidence you're going to present here today is the truth and the whole truth under penalty of perjury?
I do.
Thank you. And if you could just state your full name for the record.
Aaron Bryant Anderson.
Thank you very much. Go ahead, Miss Winkles.
Yes, Mr. Anderson, how old are you today?
38.
Okay. And you were in a relationship with Miss Erickson at some point in the past, is that correct?
Yes.
Can you tell us about that relationship, time period, what it was like, anything to let the court know, kind of the background?
Off and on between 2015 and 2018. Very toxic. Both very active in drug use. Very manipulative and emotionally manipulative, abusive on both ends. Volatile on both sides, both verbally, emotionally, to an aspect of physical on my side. I do believe a lot of that was with mental instability and drug use. Just very toxic and not good all around. It destroyed both our lives in many aspects. So.
And what drugs were you both using at the time?
Meth and heroin was the main.
And you said there was domestic violence on your side, is that correct?
Yes.
Okay. And you admit to the past, to what's happened in the past?
Yes.
Okay. And tell me, when is the last time you had any contact, either indirectly or directly? By indirectly, I mean text messages or anything like that. When's the last time you had contact with Miss Erickson?
August of 2021, after serving or self-serving court for the paternity test.
Okay. So kind of going back in time, when did you find out that the child might have been yours?
There was always an idea of it since 2019, or even before 2019, but there had been so many different times where she was pregnant and not pregnant and used that as a manipulation tactic that I didn't believe it until the child was actually born. And that's when I tried to follow through with finding a paternity test.
Okay. And when you filed for paternity, how long from when you got the order for the genetic testing to when you actually discovered the child was yours? How long was that period?
I got her into court finally August of 2021. It took me about 9 months to finally serve her by myself, and then I had to save enough to file or to hire counsel before I could actually get her into court to file for contempt, because I wasn't sure of the process to get her into court to force her to do it.
And so it was quite a long time before you actually discovered the child was yours, correct?
Yeah, I believe it was February of 2022 when I finally got her.
And so that's now taken care of. So tell me about what you've done. So I guess let me go back in time. So you were in active drug use. You had some criminal charges, and what changed?
Knowing that I had a child, I needed to actually be somebody responsible and be able to provide not only for her, but have a healthy lifestyle for myself. Because if I can't take care of myself. I can't take care of her.
So tell me some of the steps you've done to change your life.
Not only did I get my medical situation taken care of by the 2 months in the hospital, but I have found gainful employment. I have taken the evaluations that were recommended and followed all treatment programs, even continued to take UAs past completing the treatment programs, volunteered for extra treatment programs, took extra parenting classes through the same treatment place, just to, get extra skills and MRT classes. I've gotten a house. Sorry.
Let's go through some of these documents then real quick. We have as Exhibit 1 petitioner's wage stubs. Are you still working at the Overhead Door Corporation?
Yes, it's Wayne Dalton Garage Door Manufacturing, a subsidiary of Overhead Door Corporation.
Okay, and how many hours a week do you work?
I do my best to maintain the 55, but guaranteed 40 a week.
Okay. And what are your hours of work?
6 a.m. to 2:30 p.m. But if I can get overtime, it's 5 a.m. to 3:30 p.m.
Okay. And your pay stubs, are those true and accurate copies that are in Exhibit 1?
Yes.
Okay. And Your Honor, I'd ask to admit Exhibit 1 into evidence. It was in the ER 904.
All right, I'll admit Exhibit 1.
Okay. And now your work hours, obviously that would be during the morning period. Have you set up any care or support for the child between the hours of when you're gone at work? So it was like 5:30 in the morning to 2:30 in the afternoon. What have you done to set up some sort of support for the child?
I have found several daycares. There's actually one that's not even a block away from my place of employment. But to have her completely enrolled, I have to have a copy of her immunization records. And unfortunately, with no communication between me and Miss Erickson or any of those documents, I haven't been able to guaranteed enroll her. But there are several daycare facilities around here that are able to maintain. I also do have support from my parents that would be able to help. I also have a coworker that has a child that is in childcare that would be able to help me with that.
Okay. And you live currently is that correct?
Yes, South.
Okay. And as Exhibit 2, is that a copy of your lease agreement between you and the owner of that residence?
Yes, American Property Management.
Okay, and Your Honor, I'd ask to admit Exhibit 2 into evidence.
All right, 2 will be admitted.
And how long have you lived there?
Since January 3rd of 2023.
Okay, and do you have a room for the child ready there?
Yes.
Okay. And your closest support, such as your mom or someone like that help you with the child, how far away do they live?
Parents are in Vader, Washington, but I do have one of the people that was one of my I'm not sure of the term, but people that talk to Vashta Langford lives here off of 82nd, just 30 blocks away from me here in Portland. Lisa Dale. She is a very close friend I've had since high school. So.
Okay. And are you currently in a relationship?
No, I plan on staying single and only focusing on making sure my daughter knows that she's the most important person in my life right now. I didn't want her confused or thinking someone else was more important.
Okay. And if we turn to Exhibit 3, it's the LabCorp. It looks like the genetic testing. Is that a true and accurate copy of the genetic results showing that you're the father of the child?
Yes.
Okay. And Your Honor, I'd ask to admit Exhibit 3 into evidence. It was also part of the ER 904.
3 will be admitted.
Okay. And so we'll go and talk about some of the evaluations you've done, but let's talk about some parenting classes. Tell me about the parenting classes you've taken.
Parenting and family values. It's not only about skills, but it was also included in MRT. I'm not sure what the abbreviation is, but it focused on faults that might have been caused due to drug addiction or mental health issues, and how to overcome them, and how to gain coping skills with stresses and anxieties, and how to work through them instead of falling into bad habits of relapse and old habits of drug use and self medicating
Okay. And
situations.
how long have you been free of drugs and alcohol?
Almost 3 years now, since I want to say the 2019. I don't have the exact date in my head. So
Okay. And you had a hospital stay at some point, correct? Where you had a growth on your heart?
yeah, it was a bacterial vegetation inside 3 of the ventricles of my heart. It was greatly affecting not only my physical health, but mental capacity for emotional regulation. It took me 2 months, a little over 63 days of IV antibiotics 3 times a day to get rid of it. And that was due to my IV drug use.
Okay. And is that the last time you used drugs?
It was before the hospitalization was the last time I used drugs.
Okay. So it was before. So if we turn to Exhibit 8, I have your H&P from your admission on November 16th, 2021. Are those true and accurate copies of your medical records from that time?
Yes.
Okay. So you had already stopped using drugs prior to November of 2021, correct?
Yes.
Okay. And it shows that you had MRSA and due to endocarditis, and that you also talk about your previous drug use. Is that correct?
Yes.
Okay. And Your Honor, I'd ask to admit Exhibit 8 into evidence. It was also part of the ER 904.
Right, 8 will be admitted.
Okay. So, and I'd also, off the page here. Did you all, so kind of jumping around just a little bit here, but so you get out of the hospital, you're clean, you've taken these parenting classes. Did you also take children in between?
Yes, that was the first one I took.
Okay. And what did you learn in children in between?
It's key not to use a child as a tool or a weapon to try and conflict resolute, or even use for confliction between parents that are not getting along. A child is a child. You don't need to have them for adult situations. It's between the parents. It's not for the child. It's to work together for the benefit of the child, not use the child as a manipulation tool.
Okay. And is this at Exhibit 4, that children in between, is that your certificate of completion of children in between?
Yes.
Okay. And Your Honor, again, I'd ask to admit Exhibit 4 into evidence. It was part of the ER 904.
Or will be admitted.
Okay. So you also, you've learned children in between in these other classes. After 22, so you said you had no contact with Miss Erickson since 2021, correct?
Yes.
And
Except for the council.
Okay. Sorry. And have you known where she lived, or prior to the domestic violence restraining order being re-upped, did you know where she lived?
I knew of the area because I was trying to serve her personally. And I never had actually seen her in her house, or I had tried to have other people serve her there, but I had never actually physically stopped at her house, but I knew of the address through social media.
So even though you knew of the address, and at some point there was no protection order in place, correct?
Yes.
Okay. And during the time when there was no protection order in place and when you knew of the address, did you ever go over to that house?
No.
Did you ever do anything to contact her in any way?
No. Knowing the toxic nature between us and fear of my own freedom and what would inspire if there was face-to-face contact without some sort of mediator there. No, I had no contact with her.
Okay. Do you have any desire to have any sort of contact in the future with Miss Erickson outside of our family wizard or something like that with the child?
No, not unless it is absolutely necessary to deal with something that's going on with our daughter. There's no need for it. We obviously are way too toxic and volatile with each other when we interact.
Okay. And speaking of kind of that volatility, have you had any domestic violence evaluations or treatment?
Yes, I have had the evaluation and I have completed domestic violence, interpersonal recovery, and anger management treatment courses.
Okay. And Exhibit 10, it looks like it's a domestic violence behavioral evaluation with Olivia Lovely. Is that a true and accurate copy of Exhibit 10 of that evaluation?
Yes.
Okay. Your Honor, I'd ask to admit Exhibit 10 into evidence.
It'll be admitted.
Okay. And were you given treatment as part of that evaluation?
I followed the recommendation of getting treatment for it. Yes.
Okay. And what did you learn during that treatment?
That I had a lot more of a self-blaming issue that would build up and turn into lash outs of volatility, and that would turn into domestic violence situations, trying to please other people to the point where I would self-loathe and then turn around and lash out and blame other people for my own sadness, because I was trying so hard to please them that I couldn't please anybody, let alone please myself. And it was just a downward shame roll spiral that would constantly lead to the same habit over and over again, turning into self-medicating with drugs and alcohol, which would just repeat the cycle.
Okay. And Miss Lovely, during that that evaluation, she recommended you do the treatment, which you've done, correct?
Yes.
And she recommended a mental health evaluation. Did you do that?
I have done 3 of them so far.
Okay. And she recommended you continue with SUDS treatment. Did you do that?
Yes, I did drug treatment and relapse prevention treatment.
Okay. And she also recommended children in between, which you also did, correct?
Yes.
So is it true, as a pretty true assessment, that anything Olivia Lovely told you to do, you did?
Yes.
Okay. And I can't remember, I believe I asked for it, if Exhibit 10 to be admitted. I didn't write it down though. If I haven't, Your Honor, I'd ask for Exhibit 10 to be admitted.
It was already admitted.
Okay, thank you. I'm forgetting already. And then you also went to substance use treatment with Volunteers of America. Is that correct?
That is where I completed all my treatment programs. It's here in Portland, Oregon.
Okay, and tell me about those treatment programs. How long were they? What were they?
They were the drug treatment for my substance abuse. It was the domestic violence and anger management, interpersonal recovery. It was also relapse prevention and the family values and parenting classes. The domestic violence and anger management course was 9 months. The drug treatment was 9 months. The relapse prevention was 6 months. And the parenting and family values was 12 weeks.
Okay. And what was the name of your SUDS treatment administrator?
Dietrich McDaniel.
Okay, and Exhibit 11, is that a true and accurate copy of your enrollment verification in SUDS as of October 13th, 2022?
That is a verification that I was enrolled. I was actually enrolled June 5th of 2022, so I might not have gotten that properly into you.
Okay, and so, Your Honor, I'd ask to admit Exhibit 11 into evidence.
11 will be admitted.
And Exhibit 12, is that a full and accurate copy of your your drug treatment and mental health and counseling notes from your time at Volunteers of America?
Yes.
Okay, and Your Honor, I'd ask to admit Exhibit 12 into evidence.
Well, will be admitted.
Since you've been clean, about how many urinalysis or hair follicles or any sort of drug tests have you done?
I was on random weekly tests from June 15th of 2022, and I continued them until I believe May of 2023, and I have done one of the 90-day hair follicles. I want to say May of 2023. I can't remember exactly when I did it, but
And were any of them positive for anything that you were not medically prescribed?
no, I've passed every one that I've taken.
Okay, and a history outline of all those negative UAs, those are all included in that Exhibit 12, is that correct?
Yes.
And so you've done all this treatment and you get to the court, you find out the child's yours, you set up, you have stable housing, you have a stable job, you have a support network. What in reunification therapy was ordered, is that correct?
Yes.
Okay, and tell me what happened initially. How did reunification therapy start when it should have?
No, I contacted Allison Long. We spoke about it after the parenting or before the parenting plan was signed. She said that mom needed to reach out to her. We had court. She got a hold of me a few days later saying mom had reached out to her. I signed the ROIs. Then she said she was working on mom's anxiety about the reunification process and that things were progressing. She was hoping to start the reunification within a couple of weeks. And then about a month, 5 weeks after we had started the process, I received an email saying that she would no longer be continuing with the reunification process and that she couldn't give me any details. I immediately called her and she said that there was nothing that I had done. I had done everything with exceptional speed and was on top of everything, and that I should speak to my legal counsel because there was to find out what the next action was, but she wasn't able to go into detail. But I had done everything that I possibly could.
Okay, and then you ended up, we went back to court and Charlotte Rosen was appointed at that point, correct?
Yes.
Okay, and when did you start reunification with Charlotte Rosen?
It took about, I think, a month before I was able to get my first appointment because of lack of interaction with my daughter until she had finally gotten to visits with my daughter, and then I was able to finally get my first appointment or first in-person visit with my daughter.
Okay, and going back, lack of interaction with your daughter, that's because Charlotte Rosen wasn't able to see the child for the initial appointment, is that correct?
Yes.
Okay, and were you given any reasons as to why the child wasn't provided to Charlotte Rosen?
Cancellation of appointments before right before the appointment was supposed to be had, not showing up on time or something of that nature.
Okay, and when was the first time you had in-person contact with your child?
I believe it was September 16th. Oh, I forgot the calendar. I have every day written out with notes.
How many visits with your daughter have you had now in person?
I've had 4 1-hour visits and 1 3-hour visit.
Okay, and how are those going?
They are going great. She is so sweet and kind. She is happy. We get lots of interaction time. The very first one, she was a little bit nervous at first, but she warmed up and she co-op played. She included me and likes to take turns. She's such a sweetheart. She's asked how she feels at the end of every visit. She says she feels happy. She's asked how she would like to say goodbye, if she wants to give a wave, a fist bump, or a hug, and she chooses a hug every time. She enjoyed having dinner that I cooked with her. She enjoyed the art projects that we did together. She really likes it when I get to read her books. She really, really enjoys me reading her stories. And it's cute when she gets excited. Her whole body shakes when she smiles. It's adorable. I love it.
What was it like that first time meeting her after so many years?
Well, the very first time I had ever met her, I was a little bit quiet and a little bit nervous because I was really wanting to leave a good impression. And luckily I did, because she wanted to come back and see me again. And probably the greatest feeling I've ever had. Better than, excuse the language, or better than any drug rush I've ever had. Like, it was the best thing that's ever happened to me. I can't, like, yes, it was great. It was beautiful.
And do you, how to put this? Do you feel that you are capable of taking care of her?
Absolutely. My only focus is making sure that she is happy, healthy, safe, and finding her an education to a higher standard, not just a mediocre education. I want to find a way to get her into higher end schools, starting her off with, privatized schooling if I can afford it. And God, it's super expensive right now. But focusing on her health, safety, and happiness is my only goal. That's why I'm staying single and only focused on starting this relationship with her.
Okay, and Exhibit 24 is the Parenting and Family Values class certification that you took. Is that correct?
Yes.
Okay, and Exhibit 25 is the relapse prevention certification that you took. Is that correct?
Yes.
And Exhibit 26 is the interpersonal recovery cognitive skills group that you took, correct?
Yes, that is 3 classes rolled into one. That's the anger management, domestic violence, and drug treatment. So.
Okay, and Your Honor, I'd ask to admit Exhibits 24 through 26 into evidence.
24, 25, 26 will be admitted.
Okay. And your daughter is not potty training, is that correct?
It seems that she is still in a pull-up. Yeah.
Okay, so your daughter's still using a pull-up.
Yes.
The last visit. Okay. Was there any concerns that you had about your daughter's overall health or mental health, or was there anything that concerned you during the visits?
It seems that I'm concerned that she's not having enough of someone paying enough attention to try and help develop her, such as potty training, focusing on getting her simple education up, like, basic alphabet and numeric things up. I mean, she's almost 4. She'll be going to school soon. And as far as I know, she's not in preschool. Like I said, education is a big thing for me. I want her to excel, not be behind when she gets into kindergarten. But I will say that she is very observant. She has an intelligence to her. She's able to figure things out on her own very quickly. She's very kind and interactive. She does pick up after herself quite a bit. but I am worried that the fact that she's, doesn't seem to want to potty train or isn't engaging in potty training might be because someone's not putting in the time to try and help.
Okay. And given your toxic history with Ms. Erickson, how would you, if you would at all, facilitate the relationship between the child and her mom?
If need be, a professional mediator. It seems that her father is willing to interact and show and be willing to interact with me. He's the one that set up the video visits.
How are those visits going?
We were doing the video visits until in-person visits were happening. Video visits were good. She would talk with me. She would interact with me. She was very confused on why she was doing it because we hadn't met yet, but she would at least tell me about her toys. She would tell me about the show that she liked.
And the paternal, or the mother's father, he was the one that facilitated those, correct?
Yes.
And do you have any concerns about the child being in Miss Erickson's care?
I'm afraid that, as I said, maybe not enough energy is being put in to Ellie's development. I'm also afraid that as soon as the courts aren't directly involved, that there will be pullback where I won't be allowed to see her, and I will have to bring her back to court. I'm also afraid that there's going to be some sort of negative talk about me and the situation. I'm also afraid that she's not trying to help develop the relationship between me and our daughter.
And would you facilitate, if custody were to be suddenly reversed to you, would you ensure that the child and her mother still had a relationship? And if so, how would you do that?
Absolutely. The last thing that needs to happen is for her to lose her mother. The way to facilitate it would have to be some sort of mediator until she can find the ability for us to communicate, but all communication would have to be done through some sort of like Talking Parents app so that it all can be recorded. It would have to be, all transfers would have to be done, I believe, at a police station, because I cannot trust that there wouldn't be some sort of allegation or something negative and toxic, that volatile, to happen between us if there wasn't some sort of mediation or recording situation.
Okay.
But,
and at this current time right now, what are you looking for in terms of the parenting plan?
I'm not exactly sure how to answer that. I would prefer to have, I don't want to say I want to take custody, but I do believe that would be best at this point in time until her mother is able to stabilize and actually start cooperating with the situation.
And then after the mother stabilizes and gets, I'll get there in a second. After the mother stabilizes, would you be interested in more of a 50-50 plan, or what was your end goal once mother stabilized?
If she can cooperate, yes, I would like to have at least a 70-25, but it would be amazing to be able to work where we can actually work together for the benefit of the child. But I just don't see that happening with the way that she has fought this tooth and nail, tried to find every way that she can to prevent me from ever even having a relationship with her. I don't see her being able to work with me in any way.
So you've had to take her to court on several contempt actions, is that correct?
Yes, the only way she's willing to do what what she's court ordered to do is when she's facing negative consequences for not doing it.
Okay, and just to kind of get some of the exhibits out of the way, Exhibit 15 is the May 15th, 2023 hair follicle. Is that a true and accurate copy of that negative test?
Yes.
Okay, Your Honor, I'd ask to admit Exhibit 15 into evidence.
15 will be admitted.
And let's see, and did you pay for Allison Long to do the reunification beforehand?
I had paid her to process paperwork, and I had her ready to take the retainer, or the retainer is what it's called. She said that she wasn't going to accept the retainer until she had mother ready to actually engage in the reunification process, because she didn't want to have to go through the process of reimbursing me. So
okay. And then it didn't happen. And she sent you an email at Exhibit 19. Is that a true and accurate copy of that email?
yes.
And Your Honor, I'd ask to admit, not for the truth of the matter asserted, but just to show that he did contact Allison Long at Exhibit 19.
All right, 19 will be admitted.
Okay. And then obviously we have the contempt hearing. Exhibit 23 is just an order to show cause for the contempt hearing. Do you remember the outcome of that contempt hearing?
Yes, she was found in contempt due to the fact that she was not engaging in the reunification process, and she was dragging her feet toward it improperly. She was told to start video visits that day because she needed to engage in letting me start a relationship with my daughter, and that's normally not the process.
And did she do so?
Yes, I did actually get my first video visit that day.
Okay. I have no further questions, Your Honor.
Ms. Erickson, do you have any questions you would like to ask Mr. Anderson?
Well, with all that, it's just all this is a lot to take in. Sorry, the baby's starting to cry. It scared me a little bit. I don't know if I have anything to ask or anything. Does that make sense? Sorry.
No, that's okay. Ms. Winkles, I don't know if you noticed. So I have kind of an idea here. We'll see. I have Miss Rosen now in the waiting room. I sent a message to everyone about a half an hour ago that she did pop up in the waiting room. I don't know if we want to take her now, and then Miss Erickson, essentially, I'll allow, if you think of any questions, we can return to Mr. Anderson after we talk to Miss Rosen. Does that work?
Yeah, I appreciate you on that.
Okay. Do you need
Thank you.
Do you need to attend to your child? Do we need to take a 5 or 10 minute break?
Yeah, I need to change the pull up and diaper and formula,
Okay.
if that's okay.
We're a little bit of a crunch for time, but I understand the importance of that. So I'll keep the Zoom up and running. We can go off the record, and let's have everyone be back at 10:40, which is 11 minutes from now.
And Miss Rosen's only available until 11, but I will only ask her about 10 minutes worth of questions.
Okay, I'm going to admit her right now and just let her know that we're taking a break. But Miss Erickson, go ahead and attend to your stuff. The Zoom will just stay up and running here. Perfect. Okay, Miss Winkles.
Yes, Your Honor. If I can call Charlotte Rosen to the stand.
All right. Good morning. If I could have you raise your right hand.
Good morning.
Do you promise to affirm all the testimony and evidence you're going to present here today is the truth and the whole truth under penalty of perjury?
Yes, I do.
Thank you very much. And if I could just have you state your full name for the record.
Yes, Charlotte Ann Rosen.
Perfect. Sorry, it's loud. I'm going to mute. Go ahead, Miss Winkles.
Okay, Miss Rosen, can you tell me what you do for as a career?
Yes. I'm a licensed mental health counselor here in Cowlitz County, Washington. I have my private practice that I manage for a number of counselors, counseling services and associates. And in that practice, I do individual and family counseling and reunification therapy.
Okay, and have you been appointed in this case as the reunification therapist?
Yes.
Okay, and tell me, when did you begin or try that again? When were you appointed on this matter?
I'm not sure the actual date that I was appointed, but I know that I began services in July, meeting with the father of this year.
Okay, and so you began meeting with the father. How many times did you meet with the father before meeting the child?
I had 3 visits with the father.
Okay, and during those visits, how did Mr. Anderson present to you?
He was quite prepared for the visits. He was able to share with me the classes and information that he had gathered in preparation for reunification, as well as talking about quite openly and honestly, I think, his history that had previously been dysfunctional, and that he had addressed those issues, how he'd addressed them, and the steps he was taking to maintain a better lifestyle now.
Okay, and during your interactions with him, what he said, have you seen put into practice? Have you seen his actual behavior correlate to what he shared with you?
I think a number of things really stand out in his approach to the reunification counseling. He is always not only adequately prepared, but pre-prepared for all of the visits with appropriate questions, supplies, bringing the right child-appropriate things to the visits, thinking ahead to ask questions about what would make his daughter more comfortable, and also making sure that the business details of the process were taken care of, making sure his paperwork was adequately done on time, that he had Zoom links or would be in person, or that he was caught up financially. So he's typically been a step ahead of me actually in that process.
Okay, and were you able to meet with the mother?
Yes, I was also able, and I lost the word for a second. Did you say the mother?
Mother, yes.
Yes, I was.
Okay, and were things easygoing with the mother in order to set this process up?
Actually, there were a number of challenges in that process. Yeah, quite a few. In part, I think some of the challenges, the mother shared that she was very emotional about the process. And the first couple of contacts had to do with, I think, mother expressing the emotional overwhelm that she felt about beginning this process and some of the traumatic history that she felt she had. The details of the process were very challenging, though. I noted that I've had 7 contacts with mom, and the sessions themselves were sometimes difficult, often most likely because of coming late, 10 minutes. I think 3 of the visits were 20 minutes late. One was a no-show. One I canceled because she was 30 minutes late and still trying to come, so I just went ahead and canceled it. So that part also made it difficult. There just felt like there was always a tremendous amount of chaos. Sometimes some explanations, although they were chaotic too, but that very much affected our ability to move forward in a timely manner.
Okay, and did you have any concerns about mother, given that what you do for a living and your expertise? Did you have any concerns about mother after your interactions with her?
Well, I guess I would just echo what the mother told me, is that she felt very overwhelmed, that her life, she shared, was often chaotic, that she said she had problems with some time management, that just there was always a struggle or something that would interfere. The last visit I had with her before I started reunifying, I asked that she show up 30 minutes ahead for every appointment so that I would know for sure that her child wouldn't be distressed by the process, because that's always our focus, is child-centered. And that seemed to help to make sure that she was trying to arrive at least a half an hour before the scheduled appointment.
Okay. And in the interactions between the child and the father, how have those been going?
Well, I will say that something is going right in this little girl's life. She is bright, articulate, clean, well dressed. She appropriately shy upon meeting her based on her age and stage of development, but very polite and easygoing. She's definitely had some positive input in her life, for sure, to, I think, create that level of health in her emotional health. The contacts with her father have gone extremely well, and in some ways quicker than I would have expected. I was quite curious in this case. They had a video visit or two before they'd ever really met in person. But by the time they came to my office, after the first initial moments of shyness, they did very well. Aaron was prepared. He was quiet and followed the pace of his daughter, listened to all the encouragement and instructions that he was given about what would make the visit work. And it went really quite spectacularly well. And I don't use that word often, but it went quite well. I sent photos to both parents of how the visits went. They engaged in age-appropriate activities. Aaron is very patient in following his daughter's lead about what words to use to refer to him, so she could choose that. He didn't force upon her the nature of their relationship, just let it be really child-directed. And we've actually increased now to 3-hour visits. We had that this weekend. He's brought appropriate food for her visit, listened to her dietary restrictions, brought lots more games and activities this time. There's always been enough, but it was a longer visit, so he brought more this time.
Sorry. And as you move on, you said that what to call Mr. Anderson. Has there been anything that's given you concern about referring to Mr. Anderson as dad?
Well, very often I try to ease it and provide more comfort for the child, help them understand who their adults are in relation to them. And so we use a lot of different kinds of words for that. Sometimes we can do the basic, this is mom and this is dad, but sometimes children have been introduced to other people in those roles. And in this case, she was very clear at the beginning that she believed or wanted to use a different name for who she thought her dad was. And that happened to be mom's current partner. So Aaron respected that and stood back and allowed her to call him Aaron. But it has evolved into Daddy Aaron, sort of as the visits have gone by. And we're continuing to do some crafts and art projects to help her understand the relationship of who the adults are in her life, so it becomes more clear to her.
And you said 3-hour visits now. If we were to move towards a 50-50 parenting plan or 75-25 with dad being primary, what would you expect that transition period to look like from now till then?
Well, that's going to be a very big shift for a child at this age. I think the positives is that their contact has gone very well. So I don't think that will be the issue right there, just about increasing the amount of time. We could easily do a 6-hour visit, for example, at the next one. It went well enough. I don't think she wanted to leave at the end of the 3-hour visit. She could have easily stayed longer. But that's a life-changing experience, because it involves like a different bedroom in different, times and places that you eat, and perhaps a different childcare situation. And so that will probably have to occur over a month or two, if to transition into longer visits, day visits, overnight visits, and then the transition. Okay. Luckily, she's not in school yet, so it's easier because she doesn't have to do a change of school. But it's pretty significant still.
Okay. And have you had any contact with the maternal the grandparents?
I have met the grandfather. He brought Ellie for a few of the visits. He was very friendly and appropriate. He actually would drop Ellie off, and her older sister would stay in the waiting room. I actually kind of found myself checking more on the older sister, I think, to make sure that she was okay in the waiting room, because she was still quite young and had some concerns about her being there since he left. But she did well. I think she stayed in case Ellie needed to come out during any of the visits, but she has not on one of any of the visits left the room because she was anxious or uncomfortable.
Okay. And do you have any concerns about Mr. Anderson's parenting at this time?
Everything I've seen, in the visits that I've had has been appropriate. Not just, like I said, well attended, but pre-prepared. And following all the encouragement and ideas that we gave him, asking appropriate questions, and being quite intent on being child focused. And I think that's the kind of thing we look for, that the visit's not about him, the visit's about the child, and that's been consistent.
Okay. And any safety measures on either mom or dad, or anything that you felt needed to be in this case, or you just had an opinion about anything that you were concerned with the child?
Well, like I said, Ellie is very healthy and well developed, so something's going right in that scenario, I would say. I think mom has shared that grandparents assist and help a lot with Ellie. I would just say that it's, and mom stated this herself, the degree of chaos was pretty significant around all my contacts with her, all of them without exception. And all of my contacts with that, without exception, did not have a level of chaos. I do see a small window, and I keep that in mind in these people's lives, but the difference was significant.
I have no further questions, Your Honor. Oh, you're muted.
Thank you. Miss Erickson? Do you have any questions of Ms. Rosen?
My brain goes really blank. I don't have any questions because she's doing really good. I just wanted, it would be, I don't even know. Having her taken out of my care would be very detrimental. Is that what you've, like, I want to know if that's what I heard.
So if that question is to me, I would agree that a significant change in a child's life like that will have an impact. And so I do understand that and agree that would be a significant change. And if the court determines that a significant change is necessary, then it would need to be done very thoughtfully and carefully, because it's in support of this small child, for sure.
And I wanted to apologize for running late and stuff. I am horrible on time management. I was doing good. I had the baby and it's been all wonky. And I do apologize, and I have been working very hard at changing that. And I thank you for your extra help that you have helped me with on that situation, because it's been helping a lot. So yeah, thank you. That's it.
All right. Thank you, Ms. Erickson. Anything further, Ms. Winkles, then for?
No, Your Honor. I thank her for coming today.
All right. Thank you so much for your time. You are excused.
Thank you.
And Your Honor, I have no further, sorry, I have no further witnesses.
All right. Ms. Erickson, did you think of any questions that you may have wanted to ask Mr. Anderson?
I just don't want to say something that's not appropriate if it comes out wrong. You know what I'm saying? Like, I don't want to ask the wrong thing.
I understand that you're nervous, and I understand that you're not an attorney, and this is probably a pretty emotional process. And so I want you to feel as comfortable as you can. So don't worry about phrasing. If whatever, if you have some questions you feel that you need to ask or want to hear the answers to, by all means, just at least try to ask them.
Okay. Thank you.
And Mr. Anderson, if you could just unmute, and your video's off, and I don't know if you're able to turn it back on.
No, it's been disabled by the host.
Uh-oh.
That's weird. There we go. Okay. Sorry, I very well could have done that, but I didn't intend to. All right. Thank you. Go ahead, Miss Erickson, if you have anything.
Okay. I do have a question because of me doing the 10 panels of the drug panels. I have no problem doing those. Like I said, why did you only do a 5 panel?
because I had been taking weekly UAs for over a year up until that point. So I had weekly UAs backing me up, and there was no other records for you.
I have other records. Okay, but anyways, I was just wondering because I thought that you were supposed to take a 10 panel as well, since the judge required us to have that done. So that's my only question. And what's your clean date again?
Something around, it was before 2020, before I went to the hospital. So
You said 2021 though first. I'm in
yeah, before I
sobriety
went to the
very,
hospital.
very seriously. I just want to put that out there.
The infection in my heart caused quite a bit of mental incapacity. Like, it caused me some actual problems in my brain because it was blocking almost 40% of the blood flow in my body. So I actually had some issues with memory. So
Okay.
these are things that I'm dealing with on that.
Yep. And this is really, it's hard because I am not an attorney, and I don't even know courts. And when and if Ellie comes and visits at your place, will you have the proper things of her allergies to take care of? Would you take care of her allergies?
I actually would like to put her on my health insurance that I have, but I need to get the information to do that but I need the information. All I know is that she has a dairy allergy. I don't have any of this information because we don't have any communication.
She's been on hers and since she was born, so she's completely fine on her insurance. All of us are on the same, me and my kids. But I just wanted to make sure that she would have like the almond milk, and make sure like the breads, because it's all wonky. I talked to Charlotte about it. There's different words that people use, and I worry about her allergies. Both her and the baby are actually highly allergic to milk, to dairy products.
I've gone out of my way to make sure there was absolutely no dairy in any of the products that I brought when I brought food for her to have snacks, bread, all of it. I made sure. The last thing I want to do is harm our child.
Okay, but yeah, I have the only thing the really, really big questions were the clean dates, and a lot of like throughout all this, I don't even know if I can even comment on or ask questions about the entire thing. But I do have questions on your truthfulness, because you have not been very 100% honest. And that concerns me over my daughter. It really does. We have an honest, like, me and my children ever since I got clean and sober.
Your Honor, I'm going to object. It's testifying at this point, and she gets to do that as soon as we let Mr. Anderson go.
So you will have an
I'm just
opportunity
saying-
to testify, Ms. Erickson, but if this is leading up to a question, I'll give you some leeway, but this is a time for you to ask questions. You'll have an opportunity to tell me what you want me to know in a moment here.
Yeah, I think I'm done. I'm sorry, this is a lot.
That's okay. And I don't want to rush you. I just.
No, I'm good.
Okay.
Thank you.
All right. So then I'm going to ask Ms. Erickson, I'm assuming there's some things you'd like to talk to me about. So I'd ask you to raise your right hand. Do you promise or affirm all the testimony and evidence you're going to present here today is the truth and the whole truth under penalty of perjury?
I do.
And then just state your name and then let me know anything that you'd like me to know.
Okay, so my name is Brittany Adine Erickson. I am a mom of 4. Okay, so I have 4 kids, obviously now. basically throughout all this, I was served right literally day after I got out of the hospital with my baby. I had a pretty rough delivery with her, like rough. And then I got served on November, what was it? November 12th, I think it was. Maybe it might have been 16th, something like that. It's been a while. My brain's all wonky because of having the baby and slowly coming back, I guess. That's what caused me to go all like really get all upset and stuff. I didn't know how to explain my emotions, or even I didn't understand any of what I was being sent, and I still don't. That's why I hired Mr. Roberts. And he did pretty well actually explaining some things to me, and then left, unfortunately. But a lot of the things that I received, I really truly didn't understand. When bringing up the cases of my past children, those were years upon years upon years ago, and I didn't even know it then. I don't know it now. I just kind of want to make it very known that I worked because I didn't have the money for an attorney. My boyfriend was able to do some overtime in order to get that and give it to me on my birthday, which was an awesome birthday gift. Anyways, so, everything before that, having the baby, and then not even a month later, I got a tubal done. So that really threw me into a complete whack, and having to go to court every week, basically, and being told I was going to have my child, getting letters stating that they wanted to take my baby from me, when I've been completely the only one to raise her. It's been really emotional, and I think that's why I've been so overly emotional, because I don't want to lose my daughter like I did. I have kind of a PTSD from losing my children, my older ones, temporarily, from the courts. That was a really, really rough time of my life that I would never will ever go back to, ever. Once they took my babies, that's when I snapped out of it, and my dad helped me get into treatment, and I did treatment, and I've been clean and sober ever since. I detoxed and everything. I'm currently actually able to be a stay-at-home mom, which I'm loving right now. But I'm actually kind of going crazy too. So after the baby turns 1, I plan on going back to work. So I kind of want that out there. That way I'm not being made to look like I'm living, because I'm not even living on the state at all. Like, Cody supports me and my kids, and his kids. We have 6 kids together. I get so nervous, sorry.
Okay.
Let's see. It's like my brain goes blank. With my whole mental health stuff, I did do the evaluations, like I've said. I do have an extra set of copy, because I went in and got the copies for my attorney. My attorney was supposed to hand that all over to them. And now I didn't have any idea that none of that happened. He told me everything was taken care of. Like I said, he told me just to, get what he needs, and then for me to just only worry about my kids. And honestly, that was the biggest relief from having to go, to court every week and be all crazy and like afraid I'm losing my baby. to being able to be a mom, and it really it helped a lot. So when he told me he was leaving, it's like, I don't know, it went back to being like, I kind of feel dumb in court. Does that make sense? I've never been in trouble. I've never been arrested or anything like that. Like I said, I'm clean and sober for 6 years almost. It will be February 9th, 2018 is my sober date. And I take sobriety very, very seriously. Like very seriously, because I've been doing it, you know, like I'm getting my kids back. Like and with Lexi, that's not, with what Vashti had said, I was a little confused because Joshua is not supposed to have any kind of contact with Lexi, but that's another court hearing from now, you know, kind of a deal. It's only supposed to be the grandmother, and I was supposed to have her back like 2 years ago. But she's not wanting to give up my child. And I get nervous, as you can tell, when it comes to courts. I don't understand them, and I don't have the funding to continuously pay an attorney because I take care of my children. The potty training, actually, I had Ellie potty trained. It took me a week. I was so proud. She was completely potty trained and everything, and I was pregnant. And we did a calendar and we did stickers and stuff, and she got a big prize. She was all happy. The moment I had Finley was when it just reversed. It's like she went back to diapers, and I felt like I was doing something wrong. And the doctor actually told me that it was very common for her to kind of go backwards in that, especially from having a new sibling, because she was baby. Now she's the older sister. And I've talked to them several times about, because I've questioned on, because I felt like, because she had it done, she was doing great, like freaking no accidents, no nothing, and then it was just bam. So like I actually talk with her doctor and other pediatricians on different ways on helping her regain that kind of, because she was so proud, you know. I can't really use all the right words, I'm sorry. I don't, but she needs, like, what we're trying to work on right now is we're trying to we're going to do it differently. That way it's not the same as when her baby sister was born, if that makes sense. That way it's a new thing for her, and we're currently working on that. My parents have been working with her, because the times that I need breaks or whatever, they take the kids or whatever, and it's only for like an hour or two. Anyways, my parents have said that Ellie has gone potty on the potty every single time, just like she does at home. I'm wondering if maybe she wasn't too comfortable, you know, during you know, there's a lot of toys going on or whatever, and she didn't want to stop playing, maybe, is why she was continuously using her pull-up during the reunification. But normally she is using the potty. I want to put that out there. I should have wrote down everything. I am so sorry.
You're doing fine.
Thank you. What else?
Can I ask you a question?
Yes, absolutely.
What do you think would be ideal? What would be a good situation for a parenting plan? Because clearly we need a parenting plan. We have an identified father. The father wants to be a part of this child's life. What do you think would be appropriate?
I think because of her just now getting to know him, and with I thought we could just continue the reunification, not taking her out of my care, not taking her out of what she knows, what she's familiar of, like doing it so she's comfortable, you know. I think that we should just, if it's possible, allow Charlotte full for that and Aaron. You know, I'm happy for that. And I tried that right after I had her, and there was no response, no nothing, you know. So now with her finally being able to meet who her biological father is, I've been enjoying seeing her all excited and stuff, but I don't want to stop that. You know what I'm saying? Like, I don't want to take her away from me and what she's only known me and my parents, you know, this entire time until this reunification. And I think that I don't think that my custody should be taken. Of course, I don't think my custody should be taken away, please. I just think that we should just continue what we're doing, because what we're doing is doing really well, and it's not throwing Ellie out of whack. If that makes sense. I don't think that 50-50 is appropriate right now, because she's still continuing to get to know him. She literally goes to the reunification classes, and she thinks she's going to see Charlotte most of the time. Charlotte's her play buddy. Like, they are best friends. And she even says, Charlotte is my best friend. And she has a vocabulary of a 6-year-old. Like, even her pediatrician said that. And there's no way of slowing her down. I already asked, unfortunately. But because they're my last 2 babies. But she needs to understand a little bit more why she's going. She understands about Aaron being there, but she doesn't understand the father part. Does that make sense? Charlotte's my best friend. I'm going, and she says that Charlotte's office is her house. I'm going to Charlotte's house to have dinner when they had a dinner for her. And she thought that was the coolest thing. And I tried to speak to her about, you know, Aaron is your biological father. And I tried to talk to her about it. And you're going there to meet with him. I go, Charlotte, went to school to do this. This is what she does. She's our friend, but, you know, it's hard to explain that to a 3-year-old. You know, I try to go any appropriate way that I can. But yeah, to get her taken from me, honestly, and I'm not just saying that because she's my baby, but honestly, it would really mess her up, especially when she likes, you know, like, I've worked in customer service, so I've always been really, really kind to I'm a kind person, and that's how I was raised. And I've always been kind to people that I don't know, and I've shown, I guess I've shown a lot of that towards, you know, Ellie's watched that since, you know, I had her. So I think she's, you know, she's being herself, of course, but I don't think she totally understands the whole dad situation quite yet, because he's been so many years not even in contact. I'm repeating myself, I'm sorry.
Okay.
I'm just hoping that we can stick with the reunification and take it Ellie's speed. Don't rush her. You can't rush a child. You know, you can't do that. So, and she's happy. You know, like, obviously I've done something right with her, I hope, because of my upsetness and my, like, I'm really honestly trying to do a time management thing. Ever since I had the baby, it's like I get ready to leave or something and one of them poops or so, you know, it's always something. And I'm trying to work on going around that because it's been a while. And I having to go through court and just having a baby on my own because her dad only comes here once a week on Sundays because he works 6 days a week. So that entire time, especially like doing court paperwork, that's why I had a heck of a time trying to do it, having a baby in my arms and a toddler, and my brain not being all bouncy because of everything happening all at once. I feel like I'm just blabbering. But yeah, I don't know. I just mostly, like I just said over and over again, I'm hoping that we can just continue what we're doing right now. She lives with mom and we go from what she knows. We don't put her into a situation that's going to cause her distress. And we get her to understand that Aaron is her dad and she's not going just to see Charlotte and play with Charlotte, you know. She's pretty happen a lot quicker, I guess, but you know, I just don't want her to be rushed. I don't want her to be mentally messed up, please.
All right, thank you, Miss Erickson. Miss Winkles may have some questions for you.
I do. In July of 2021, were you pregnant then, or had you just had any babies?
July 2021. I got when did I get pregnant? I got pregnant. No, I wasn't pregnant in July.
Okay, so what was your excuse for taking almost a year to take the genetic test that you were court ordered to do?
Because actually that was being sent to my job. It was my job that I was no longer at. So I had no idea that was, because I called at first. I called and they said that there had been no payment and that nothing to do, that don't worry about it until they were going to give me a call back. I did that right after that court hearing. Okay. And then I didn't hear anything after that. I ended up leaving my job of employment for a better job at Albertsons. I left there and apparently you guys were sending me by mail there of court summons and stuff like that when it could have been at my parents' house because Aaron knows exactly where my parents live. But
the
reason why it took so long is because I had no idea that you guys were trying to get a hold of me. I had no clue. I called right away. Nobody had made a payment. And they said for me to wait.
Okay, but it took a contempt to get you to do the genetic test, correct?
No, it didn't. No, it did not. No, because
and then you were court ordered in our case to provide several evaluations that were collateralized with my client in the GAL, correct?
Yeah, and it's ready for you.
Okay.
They said that they
why? Hold on, we can't talk over each other. Miss Winkles, let her answer the question.
Okay. Yeah.
Go ahead, Miss Erickson.
Thank you. They said that they would, because I've talked to them several times because of this being put on me, and they said that if Vashti and knows because she's gone through them before for those kind of assessments, that she knows that she needs to get a hold of them, and I let Vashti know that I did it, and I have records of that too, of email stating that I told her I got all the things done and everything, and I would always keep her up to date on that.
So
always.
Were you here when Vashti testified that she had attempted to get any of the records that you said that you had, and she was told repeatedly that you had refused to sign a release of information to her or to my office?
That wasn't true. That wasn't true at all. That wasn't. I have proof. It's in that packet that Columbia Wellness gave me.
Okay, so we don't, neither the court, myself, nor Vashti has any information about any collateralized SUDS evaluation or mental health evaluation, correct?
Well, you guys are given
It's a
the
yes or no question. Is that correct?
I don't know. You guys are the ones that are supposed to be calling them to get the information. I'm not supposed to be calling you to have you to go do that. I've already let I let Vashti know, and I've let you know throughout court hearings that it was already done. And that they won't send it to you. You have to contact them in order to get it. Same with you,
Okay.
Erin.
And how many times have you canceled appointments with Charlotte Rosen?
Actually, I only canceled, let's see, it wasn't canceled. It wasn't on purpose. I was having actually a kidney stone, and I actually got a doctor's note over that. And I apparently supposedly missed court, but my attorney was there. So I thought that was okay, but I still have a doctor's note if anybody needs it as well. I ended up it just randomly hit me.
Okay, and how many times have you been late to appointments?
Oh, that happens all the time. With my own appointments, I'm trying to work on that.
Okay.
Like,
and
I'm a single mom, basically taking care of my children on my own.
Okay, and you said you were in treatment. Where were you in treatment? What dates were you? Let's start with where have you undergone drug treatment?
What do you mean non-drug treatment?
Where have you had drug treatment?
I am on Suboxone. I've been on Suboxone for almost 6 years. I go to Ideal Options.
Okay, and do we have the Ideal Option records?
I gave them to Vashti, and it was the only way I could give them. I don't have anything to scan. I gave them the way that I thought I could, and I scanned them off of the internet, like a free scanner. And she made it think that she made it sound like I just took pictures, but really I didn't. I used a scanner thingy that I thought anyways.
Okay, but Vashti testified that she didn't have anything more recent than 2015.
Well, that's not
so
true.
Tell me, have you been in treatment since 2015?
I have not. I've been in Ideal Options. That's it.
Okay, and why is it then that your drug test showed 0 Suboxone when you claim to be in Ideal Options on Suboxone treatment?
Actually, the lady at the lab actually said that if anybody needed to call and ask that, if you guys needed to call and ask that, she said I'm
going to object to hearsay, Your Honor.
Because I've been on it for so many years, my body has adapted to it, and I only take 16 milligrams a day. So therefore, my body is just immune to it. That's why. And she said that if you guys had any more further questions, or if you wanted more labs to be done, I have no problem doing them. But I've been on my meds for years. Almost.
Aside from Ideal Options, have you ever been in drug treatment?
Yeah, I was way before. It was right after Erin actually hurt me and went to jail. In 2017 is when my dad helped me get into Lifeline.
And how long were you at Lifeline for?
I was in detox for, I think it was 2 weeks. And then I was in treatment for at least, I want to say 3 months. And then after that, they recommended me to go to outpatient, and I did my was it 1 year or a year and a half of outpatient with Columbia Wellness.
Okay, and when Columbia Wellness was requested the records, again, did you hear Vashti Langford's testimony that they claimed that you had not signed, again, a release of information to give her any of those records?
I heard that, and that was very odd because that's definitely not even true. It's in my thing, my client thing. Like, you could see the times and days that I signed those papers.
Okay.
So
and
that's odd.
Can you tell me your mental health evaluation? Who'd you go see for a mental health evaluation?
It was a man. Mental health. That lady. It was a lady, and we did it over Zoom. I can't. She made me what I went through with being videoed.
Are you in counsel? Are you in counseling right now, or any sort of treatment?
Yes, I am.
Who's your counselor?
My counselor is Joshua. I can't remember his last name. I have to go on my phone. It's
Where's he at?
Sandaker. Yeah, it's Joshua Sandaker, I think it is, and he's at Columbia Wellness.
And how many times do you see him per month?
I think it's a couple times a month, or whenever I need him. Like there's been times during this whole situation, I'll message him and he'll call me immediately and talk with me.
And when's the
So-
last time you had contact with him?
Let's see. I have my appointment coming up next week, and I had just spoke with him like I think it was like a week and a half ago, something like
And
that.
what's his last name again?
I think it's Sandaker. I'd have to go on my email. But it's Josh Sandaker or something like that. It's something different.
Okay. And let's see, you also, one second. Where does the child go to the doctor?
Here, I'll take this. I'm sorry.
Where does the child go to the doctor?
She goes to, we all go to the Vancouver clinic.
And what's her doctor's name?
The doctor's name is, you're asking me and I am having brain farts right now. My dad's still diaper for this. Her doctor's name is, I'm having a brain, hold on. I can tell you in a second. There's that, sorry, Daddy. I have paperwork actually right here because I'm brain farting because you're asking me and I'm nervous. Her name is Dr. Nudell.
At the Vancouver clinic? Is that the one in Woodland?
I didn't know that they had one in Woodland.
Where is that one? Is that the Ridgefield, the Battleground?
In Vancouver.
Oh, it's in Vancouver. Okay. And when was the last time the child saw the doctor?
She had her routine. She had her yearly checkup actually, and I was trying to get her in. I thought I had to get her in a little bit sooner, and I tried to get her scheduled with Finley because their birthdays are coming up, and they said that they didn't need to see her because she was already seen, like 10 months ago. I think it was like 10 months ago, 11 months ago.
Okay, so she was last seen about 10 months ago. And is she currently up to date on all her vaccinations?
Absolutely.
Okay.
Absolutely.
And where does she go to the dentist?
She goes to Happy Kids.
Okay. And when's the last time she had a dentist appointment?
She recently just did when I actually ended up having to reschedule it because you guys made me go to court on the motion to compel when Scott was still with me. Whatever day that was supposed to be.
When did she last actually go?
She last actually went. Let me see. I have pictures. And it can tell me exactly. Sorry. All days running together when you have a baby. Let's see. It was. Let's see. Because she doesn't have to be back for another so many months, and she did really well. Let's see. I'm sorry. I'm trying to find it.
Was it more than 6 months ago?
No.
Okay, so she's been to the dentist within 6 months.
Yeah, I'm looking right now on my. It was
A ballpark's fine.
It was September 8th at
Okay.
2:15 for appointment.
And did she actually attend that appointment?
Absolutely, yes.
Okay, and did she have any issues at that appointment?
No. The only
Okay.
thing she's afraid of is the little sucker thing. So we're trying to also go through because she tries to hold in her feelings. She's
Okay,
I
well,
don't
just answer when I ask you what the question, just answer those, okay? What's your boyfriend's name?
his name is Cody.
What's his
His
last name?
Henson.
How do you spell that?
Pinson.
And where does Cody live?
He lives in Oregon.
Okay. And does Cody have a criminal record at all?
Not that I'm aware of. His uncle was actually Chief Ralph Painter. So no.
Okay,
He
and Oh, go ahead.
Sorry, he has a pretty clean record. Yeah,
And his last name is Pinson?
yes. And then his first name, he goes by Cody, but it's Jonathan Cody. Does that make sense? His mom apparently didn't like the name Jonathan and then named him Cody. I don't know, but he goes by Cody, but it's Jonathan Cody. I should have said that first. Sorry.
And how old is Mr. Jonathan Cody?
He is he just turned 45.
Okay, so was he born in 1978?
Yes.
Okay. And to the best of your knowledge, you don't know if he was ever arrested for anything. Is that correct?
I know that he had he had, like he was drinking, or he said something actually recently, because he told me he had nothing on there, and I'm like, you can't be that good. He told me that he had a couple of DUIs that he was pretty ashamed of, but that was it. There was no drugs. He says he's not on drugs.
Okay, but he had a couple of DUIs in the last 10 years, correct?
I don't know exactly when it was, but he admitted to me, not very probably.
Have you heard of any domestic violence charges against him?
I heard that there was one that was against him, but it was false, because it was actually her that was it was his stepdaughter's mom, who actually was the aggressor in it, but he was the one that was arrested in it, and it was actually let go. Supposedly, I don't know. I didn't look into 100% of that. But
and
I
that
did
was
get
in Washington, correct?
Vancouver, I do believe.
Okay.
Yeah.
And then he has additional charges though out of Oregon, in Multnomah County. Isn't that correct?
I don't know. That I really honestly don't know.
Okay. And he stays with you one night a week?
He doesn't stay with us. He just comes over. Him and his son come over for the day.
Okay. And that's the father of your child, your youngest child, correct?
Of the baby, yeah.
Okay. And has the child in this case, has she been enrolled in any daycare?
Not currently yet, because I've been able to stay at home with them, and I've been able to do the whole stay-at-home mom thing.
Okay. And she's
here. Sorry.
She's currently not potty trained, correct?
The baby?
The daughter, in this case, Ellie.
No, she is. She's potty training.
Okay. She's in a pull-up though, correct?
That's potty training.
Okay. And when does she turn 4?
Next month.
Okay. And last week, if we look at just last week, how many days did your parents have Ellie in their care custody?
Of last week?
Mm-hmm.
How many days okay, say that again, sorry.
How many days did your parents babysit Ellie last week?
They don't babysit her. She just goes over there.
Okay, how many days did she go over there last week without asking questions?
Twice.
Okay, and the week before that, how many times?
Twice. Once or twice. My dad works.
Okay. And you said that she had insurance. Is she on state insurance?
Yeah, and actually she was getting put on my insurance.
Is your insurance
with the job that I was working at, and then Yep.
Okay, and you currently are not working, correct?
Not currently. I am looking to go back here with the baby turning 1.
Okay, and do you have any current or active warrants against you?
I've never been in trouble.
Okay,
And knowledge.
Okay, and you had an open dependency case, and that's how you lost one of your children, correct?
It wasn't the reason why, no. Actually, that was the grandmother, the dad's mom,
Okay.
calling start stuff. But no, it was not dependency. It was over DV.
Okay. And who sent you letters telling you your child was going to be taken away from you?
Over this.
Are you talking about the court pleadings, or are you talking about a letter threatening you?
Oh, I'm talking about just like you guys saying that I'm on like all these false accusations against me and then trying to take my baby from me.
Okay. Concerning the last 2 years, so that would be October 2021. How many times since October 2021 has Mr. Anderson directly contacted you?
Just because okay, so directly none, but it doesn't mean that he hasn't driven around here.
Okay. Do you have any proof that Mr. Anderson was driving around your house?
I don't have picture proof, but I have children proof.
Okay. What kind of car does Mr. Anderson drive?
It's like a maroon color.
Okay. Is it an SUV, a truck, a station wagon? What kind of car is it?
It's an SUV. But
Did
it
he
could
have
be
that? What was that?
it could be different though too, you know.
Okay.
A red car, like a car.
Okay. And but Mr. Anderson's not contacted you at all, correct?
No,
Okay.
not
And at some point there was no domestic violence protection order in place, correct?
I had no idea of that until Vashti told me.
Okay, but there was not one in place at some point, correct?
I had no idea because I was never given any kind of inclination of the court hearing.
But you know now that there was at one point no.
I know now. I know now.
Okay. And Mr. Anderson still did not call you, correct?
I don't even understand these questions. These are stupid. Sorry, no offense. I don't understand them.
Okay, you don't need to understand, just answer them. Did he contact you during that time period where there was no domestic violence protection order?
I don't think so. I don't know. It's just, I don't know.
Do you remember if he contacted you at any time in the last, well, I guess you said the last 2 years he hasn't contacted you, correct?
Not face to face or verbally.
Okay, now we had a temporary parenting plan entered in this case. Do you remember that? It was around June.
Yeah, and I was not, that's when that is when I was getting the attorney and him and I had a fallout about that actually, but
Okay.
yes.
Did you allow for the video visits during that time? Did you have video visits or the child have them with Mr. Anderson?
I wasn't aware that I was supposed to.
Okay.
I was aware that because of what Vashti said was that after reunification, after completing reunification, to start the video visits, not before reunification. And you made it to where it was before reunification, which made it very awkward for my child and Aaron during the visit.
Now you were in court, correct? The hearing before the June 6th, where the court informed you that he had the right to video visitation prior to his initial counseling. Do you remember that?
But he's never ever met her, before. So my child was talking to a stranger.
But do you remember the court ordering you to comply?
I really don't remember that. No.
Okay. Do you remember the court ordering you to comply with decision making of the child?
Yeah, and I felt that that wasn't appropriate because with him not being a part of her life and now just becoming a part of it, why would he be able to do decision making? And I was trying to work with my attorney on that.
Okay, so when the court orders you to do something, but you don't agree with it, you just choose not to do it. Is that right?
I didn't know I was supposed to do anything. I didn't know I was not supposed to do anything. I thought that was after reunification. It was supposed to be after reunification and stuff like that. As we went further, we got to know our daughter first.
Do you remember the date on which you actually purchased the Talking Parents app?
My father purchased it actually,
and
it was
the month. that he purchased it?
Really don't, because it was my daddy that did it.
Okay, isn't it true that it took you almost 3 or 4 months to purchase that despite being ordered to do so by the court?
No, it's because I literally thought that we didn't have to do it until after what I understood. I did not understand because I'm not an attorney. I do not do your job. I had no idea that from what we said, that we were going off of what Vashti said. You said you typed it up word for word. I remember you saying that. It wasn't word for word.
So, quick question. Now, I've obviously asked you for discovery a number of times, and sent you a number of documents. The court's asked you for it. Vashti's asked you for it. Isn't it true that you have never provided me or the court or Vashti with a collateralized mental health evaluation?
That is not true, because my attorney was supposed to do that.
Okay, but you have not provided the court with a collateralized mental health evaluation, correct?
Scott said he was doing.
Have you personally ever provided the court with have you personally ever provided the court with a substance use disorder evaluation, which was collateralized?
Again, was supposed to be Scott.
Okay. Question to you, have you ever?
I did not turn anything in, but I can if you guys need me to.
Okay, and have you ever had, let's say, so those are the two, and in your last 2 cases with your other children, you were also ordered to do those things. Did you present them to that in those cases?
I didn't do them back then.
Okay, and why should the court believe that you would nurture a relationship with Aaron Anderson at this point when you've literally dragged your feet so long that it's taken over 2 years to even start reunification counseling?
I didn't drag my feet. It's not my fault you guys came after me right after I got out of the hospital from giving birth to my child. And then before all that, sending court ordered stuff over court to my ex job establishment that I didn't even work at for months prior. I had no idea. What it took was my friend is a server, and she seen that my name was in her serving list, and that's how I found.
Isn't it true that your parents were served according to the certificate of services?
No.
Multiple certificates of service filed in this case?
Nope, my father's standing right here too. He can even vouch that he was never served anything.
So Mike Gilman's never been to your parents' house to hand documents to you and told that you weren't there? Yesterday was the only time that I'm aware of. Your Honor, I have no further questions.
All right, and Miss Erickson, any other statements you would like to make?
No, I'm good.
All right. And any closing statements, Miss Winkles?
Yes, Your Honor. Normally, it is traumatic to remove a child and to change a child's housing. But in this case, it's a necessary safety precaution. You've heard from Vashti Langford, you've heard from Charlotte Rosen, that we just don't know here. This is a mom who has lost 2 of her other children. This is a mom who admits to having a substance use problem, but provides no records of treatment. I don't remember his name, or his name is something like that. No definitive information, claiming she had counseling at the emergency support shelter, which doesn't provide counseling, Columbia Wellness, all these things. Mother has essentially dragged her feet and provided absolutely no information to verify what she stated. We don't know if she's on drugs. The hair follicle that she did came back negative. She takes according to her, she takes 16 milligrams of Suboxone. Nobody is immune to Suboxone. You may form a tolerance to Suboxone, but it's still going to show up after breakdown in your body on a hair follicle test. That's just standard chemistry. The fact is that we don't know whose test that was. We don't know anything. We don't know if she's on drugs. Everybody that has come in contact with mom has said that she has a significant mental health problem. They have been trying to get her treatment since 2016. Her own mother wrote a declaration in one of her cases about her opiate addiction and her mental health disorder. She claimed to this court that she had custody of 3 kids. That's not true. You heard from Vashti Langford that said that that's absolutely not the case. We've heard my dog is sick, I've been pregnant, I've had a child recently as an excuse for literally everything. Yet in this world, we have lots of mothers that have had children that go on to work every single day and do that. And yet she uses that as an excuse for canceling meetings where her child is going to be with her father. There is a significant concern of health and safety. And the fact that her parents are there assisting her shows a delegation of parental duties anyway. And that's a good thing. We're not saying that's a bad thing at all. In fact, her father has been the one to facilitate pretty much all of the visits thus far. My client, the moment he learned he had a kid, he completely changed his life. And he is probably one of 2 success stories in the last 7 years of practice in Cowlitz County. He has gone through every treatment imaginable. He's provided the records to those. He's provided the UAs, the hair follicles. He's provided literally everything he can. You heard from Charlotte Rosen about how he comes prepared. He's ready. He engages the child on the child's level, and the child has started calling him Daddy Aaron. We're not asking for an immediate change of custody. We're essentially asking for a change slowly, maybe with grandparents. I'll leave that up to your honor, but my client does not want to have the child hurt, traumatized in any way. At the same time, something's not right. And the child does need to be protected. My client is willing and able to care for the child, has a place for the child, isn't dating anyone, definitely isn't dating anyone with DUIs, assault fours, like Mr. Cody Pinson, Jonathan Cody Pinson. We have a stable environment available, and we have a very chaotic environment. Eventually that chaos is going to affect the child. Mom needs to have a mental health evaluation with treatment. It needs to be collateralized, and mom really shouldn't have unsupervised treatment until she gets that, because everybody has been asking since 2016, and mom just doesn't do it. Mom doesn't follow court orders. It's likely that if mom continues to have custody and continues to have control, that this is a man will be back in court every single week on a contempt. It took a contempt every single time, or a compel, to get anything, to get anywhere. My dog is sick, my baby's sick, my other baby's sick, my parents are sick, I have dentist appointment. Every excuse has been thrown at us. It's taken over 2 years just to get to this point where my client gets to meet his child. That's frankly ridiculous, considering my client has done every single thing imaginable to show that he is a different person. The thing is, he is a different person, but Miss Erickson is the same person. And that's the problem here. And this child needs to be in a stable environment. She's almost 4 and not potty trained. We have information about who her doctor may be in Vancouver, but no doctor's records, no medical records whatsoever, no information. We don't know if she's vaccinated, if she's not. We don't know if she has allergies. Apparently she says she does. We know nothing about this. We are given no information, no assistance. The fact is that mom will continue to disregard dad, whereas dad has said openly and honestly, he will facilitate that relationship with mom. He has zero desire to take the child away. He knows what it feels like to not be able to see your child. He wants her to be able to see the child, but she needs to be stabilized. That has been throughout this, the guardian ad litem and the reunification counselor all saying there's chaos, it needs to be stabilized, there's something going on. So your honor, we'd ask that my client be given the parenting plan that we put in place. It's one of the exhibits. It is a full custody plan with a transition. Charlotte Rosen said about 1 to 2 months. We'd ask that we transition where dad starts having a 6-hour visit twice a week, and then dad goes to an overnight, and then eventually we get to either 75-25, but supervised until mom actually gets that mental health evaluation, and then maybe a review in 6 months, because the idea is for 50-50 custody or something similar to that. But right now there needs to be some safety measures in place to protect the child from mom. It sounds like her parents are doing a great job of doing that. But really it should be dad rather than a third party that has the child. There's nothing more my client can do to prove it. He's literally done everything. So we ask that you enter our parenting plan. We put a child support order in, but Your Honor, my client would rather not have that and rather Miss Erickson use whatever money she has available to get herself treatment. My client would like to put the child on, instead of state medical, put it on private medical. My client will pay for the premiums of that through his work. It's excellent insurance. The child, if she has any allergies, she'll be taken care of by a private doctor. No need for Happy Kids Dentistry. She can go to Willamette or one of the other private dentists. He has great insurance. My client wants to start assisting Miss Erickson in any way that he can. It's time to kind of move forward. And if it sounds like this one baby is so overwhelming to Miss Erickson that she can't function since she's given birth, my client's willing to take the load off of her for a little while until she gets stabilized. Thank you.
Thank you. Miss Erickson, any final comments?
Yeah, all that was just bleh. That's all I can say, honestly. I'm looking out for the best interest of my child, and it upsets me when I hear stuff like that, but you know what, she doesn't know me, so I'm trying to put that aside. I've already expressed about, why I was like all emotionally crying, like from my hormones and stuff. And obviously I'm okay now. And I can be okay tomorrow and the next day. I've obviously raised her okay, like really good actually, because Charlotte actually gave me some good compliments that made me actually tear up, because it made me feel good that I actually did, that I did really good job being her mom by myself. And supporting her on my only paychecks, by myself. Child support actually is already trying to go after me for $600, so she's not telling the truth on that, and I have the paperwork to prove it. For spousal support when I've never been married. And obviously my baby is not overwhelming. She is very, very quiet. She's a pretty chill, like her and her sister, they're two peas in a pod. It's very cute. It's like they know baby talk. They'll sit there and look at each other and start giggling. I asked that please don't take her out of the home that she is familiar with since I had her. Yeah, I had emotional, hormonal times, especially because of what I went through with Aaron. He put me through a lot. But I'm also working with the counselor that is helping me overcome that. And I didn't realize that that was bothering me, but it's never affected me as a mother either. It just did when I was, being taken to court and, accused of doing all these drugs and stuff when I've been almost 6 years clean and sober, which, mind you, with the hair follicle, the lady, her name is Linda, actually, that works there at the hair follicle place. She said that if him or his attorney needed to get a hold of her to ask about that, because about my Suboxone not showing up because my body is actually immune to it. It actually happens to more people than you think. I was pretty surprised by it too. So she had to explain it to me, but it is actually a situation. And she said that if they needed to do any further chemical, any further tests to prove my Suboxone, that's not a big deal. And I have no problem with that either. Because I take my meds as I'm supposed to. My life is being a mama. I love my life. I love my life being clean and sober, and I don't plan on to ever go back. I wasn't that person before all that, and I made a mistake. And I didn't realize I made that mistake until my children were temporarily taken out of my care. And I've worked hard since 2017 of getting clean and sober I've worked very hard every day just to make sure that I do get them home. With my son, he's old enough now to where he's in high school. I don't want to, he tells me when he wants to come over. That's how we are. That's how it is. But Lexi's looking forward to coming home. So I need to get my fear over court gone or whatever. But I never tried to stall. So I apologize to people that thought that I was doing that. I just don't know court words. I don't understand it. Even when I was getting help through Northwest Justice and Clear, they would go over it over and over and over and over again. And I still didn't understand what they were trying to tell me. I'm not going to make him continue to go back to court. That's not what I'm doing. This is over Ellie. This isn't over my feelings. This isn't over his, obviously. And that's why he's trying to take my baby from me. Especially trying to get child support before he even got her to stay the night. Like, that's ridiculous. Blew me away. Yeah, I don't have very much to say, but I beg for Ellie's feelings to be taken into consideration over this, because it's not, Ellie's safe, obviously. I've been her mother since day one. I've taken care of her by myself since day one. Never once has there been a CPS thing on me. I've never been in trouble. My children are my world. And I can't lose my other one. Sorry.
You're okay.
Emotional over that. But yeah, I just please think of Ellie. She's only 3, almost 4. And she's like I said, she thinks that Charlotte's her best friend. And then Aaron's there. So which I will continue to work with her on that. And I will talk with Charlotte and see what the best way about that is. Because I've been doing that. Asking her what I should say and what I should not say after visits, because I don't want to make my daughter feel any less comfortable. But yeah, I have nothing else to say. I just please take her feelings into account, and her sisters. And mine, I guess. I mean, mine don't really matter, but it's hers that do. And I promise you, I see a counselor. And before that, I was seeing counselors at the women's shelter. I thought they were counselors, they're advocates. I was told that, because I thought that it was a counselor, because I was scheduled for counseling sessions and with the advocate. And I thought that that's what it was. I never understood that they're not legally, before all this, but they were still somebody to talk to. And I actually lived there for quite some time, from being kicked out of Aaron's place with my daughter. So I just felt more comfortable talking to them, if that makes sense. So I thought I didn't mean to cause any issues over any of the evaluations. I have them. If anybody wants them, I have them. I thought Scott was going to put them in. I might be a little bit slower than most on doing all this, but I'm trying. I am just raising my children on my own. So it's not as easy to get up and go like Aaron, because he doesn't have any kids to tag along or have to, get ready and give him breakfast and do everything else. But if he did, I promise you, his whole world would change. His time schedules would change, because you go by their time. So that's all I just really want to say. But I am working on that too.
All right. Thank you, Ms. Erickson. Ms. Winkles, anything further?
No, Your Honor, I just ask that you enter our parenting plan that's in the file as an exhibit. Their incomes, we imputed mom at minimum wage. Again, my client doesn't really need child support, but we put dad's actual income down. You'll see his records there, or his pay stubs there. So we just ask that you start the transition, and then maybe a review.
Right, you cut off that last thing you said, cut off.
And we ask for the parenting plan to be instituted, transition with grandparents facilitating, and then a review in 6 months. If mom is stabilized and actual counseling records, actual evaluations, collateralized are submitted to both myself, I'll stay on the case, and to the court, we review in 6 months, and then again, you can reassess then. And I don't think my client has any issue with that, because again, he wants there to be 2 parents in this child's life, not just one.
All right. Okay. This is a very interesting case, and a difficult one for everyone. The process that clearly, we have a child that's 3 years old, almost 4, and 2 years ago, a little more than 2 years ago, Mr. Anderson started a process to try to establish whether this child was his biological daughter. It took a while. Once that was established, this turned into essentially a parenting plan case at the beginning of this calendar year. So it looks like almost 3 years, or coming up on almost 3 years, that this process has been ongoing to work on this. Want to say a couple of things. Clearly, I think there's a lot of unease that both parents have with the other. And that's likely because their circumstances when they spent the majority of their time together were less than ideal, not only physically, but emotionally. It sounds as though there was a lot of trauma associated with their relationship, drug use, physical, mental abuse, turmoil, lots of issues. One thing that I would really want to note is that Miss Erickson has indicated that she has made changes, but I think it's difficult for her to understand that other people can change too, namely Mr. Anderson. What I have been shown is that Mr. Anderson has taken almost every step imaginable that the court can think of to try to show that those changes have been made. That the issues he was struggling with have been addressed and continue to be addressed. And not only anger management, substance abuse, mental health, and has taken parenting classes on top of that. So we have to acknowledge that even though this child may have been born out of a very tumultuous and toxic relationship, that these parents, and while I have zero proof that Miss Erickson has made changes in her life, I'm at this point taking some of her comments at face value. And I think Mr. Anderson needs to do that as well. One thing that I noted when Mr. Anderson started speaking about the child, both parents' faces lit up. Miss Erickson clearly enjoyed hearing all those wonderful things that Mr. Anderson had to say about that child. And that child has been primarily raised by Miss Erickson. That's what I think both of you need to really glom onto. There is a mutual love for this child. Mr. Anderson cannot be faulted for not being a part of this child's life when it took so long to establish that he was even the father. Miss Erickson must be credited for where the child's at up until this point, because she has been raising that child. Mr. Anderson testified, Miss Rosen testified that this is a lovely, lovely young lady, that she is potentially wise beyond her years, a kind individual, willing to engage, and has been actively participating in this reunification counseling. I don't think anyone could ask for anything better than that situation here. And so I think that is to Miss Erickson's credit, and that is to Mr. Anderson's credit, because he came into this fully prepared to take on this role and be ready to kind of roll with whatever this reunification process would bring, whether that was a great experience, a not so great experience, a work in progress experience. And I'm really happy that it has been a good experience. We can't assume at this point that history is not going to repeat itself, or that history should dictate what we do moving forward. I listened very closely to Ms. Rosen, and she indicated that there should be a continued reunification process, that it's going quicker than she expected, better than she expected, but she still indicated at least a month of more interaction. And I assumed based on her comments that would be with her assistance. And I think that is more than appropriate, which puts me in a position where I feel, I don't want to say it's premature to make a permanent parenting plan, because even Mr. Anderson's request is that ultimately to get to a 50-50 parenting plan, that both parents figure out a way to work out what's best for this child. I think Mr. Anderson does want to provide support for the child, and by way of supporting that child, to Miss Erickson. Miss Erickson clearly does not seem ready or willing to accept that at this point, and I can understand that given the history. But the fact is this is Mr. Anderson's child as well. What I'd like to see happen, so, and this may not make everyone happy, but I have to consider what is in the best interest of this child. What I'd like to see happen is that we continue the plan that Ms. Rosen has in place for reunification. She indicated that that is going to be increasing the visits, and that will increase to overnights. I think that's appropriate. I think we need to follow Ms. Rosen's plan for reunification. And I want to see this case back on December 19th, 2023 at 1:00 p.m. And here's what I also want to see. And I want Ms. Erickson to listen very, very carefully to what I'm saying. And I guess let me for Ms. Winkles, since likely any orders are going to come from you, if Ms. Rosen believes that as part of reunification, then that means dad gets a weekend with the child, then dad gets a weekend with the child. Whatever is appropriate as we move toward that December 19th date. That is, I think, one of my last normal domestic dockets. So that's why I wanted to put it there and not put it out further. By December 19th, Miss Erickson has indicated that she has information that really, frankly, is necessary for this court to make an appropriate decision. So Miss Erickson, I need no later than December 8th. That's a Friday. Close of business. So by Friday, December 8th at 5 p.m., Miss Erickson needs to provide proof of the mental health evaluation that she has completed. And that has to be a mental health evaluation that's been done in the last year. If one has not been done in the last year, then she needs to do a mental health evaluation.
And is that collateralized, Your Honor?
Yes, and so that means there needs to be a release of information, and that release of information would need to include Miss Winkles in her office, Mr. Anderson, Miss Langford, and Miss Rosen.
I do have a question, so I don't get this wrong. Do I have to contact Miss Winkles after I, turn, like I, the evaluation isn't going to go over a year. So, but, so I know with collateration, I guess, am I supposed to let them know after
You
I
need to file a release of information when you do that and indicate to them. So if you did the evaluation 4 months ago, then you need to go back to wherever you did the evaluation, do a release of information and say that these parties need to be spoken with. And if that means that there needs to be an updated evaluation that you need to partake in, then you need to do that. So you have to let Miss Winkles know where the evaluation took place so she knows where to contact. So you can't just, I did the evaluation, I signed the release of information, but not let Miss Winkles know where to contact. Does that make sense?
Yeah, I'm very sorry about that.
And then I'm also going to order a new hair follicle.
Absolutely.
And I would like that to be a 10 panel. And as soon as you get the results of those, you need to provide a copy to the court. So you just bring that into the second floor, a copy of that. The clerk's office will let you know how to file that in your case, and then provide a copy to Miss Winkles. Okay.
And that's paid out of my pocket, right?
Yes. At this point, yes.
Okay. No worries. We'll get it done. You don't want the UA that goes with it? I'll do a UA too. I'll give you the whole thing.
If you want to do the whole thing, then we'll take the whole thing. Okay. And to Miss Winkles, I would ask that if on that same filed by December 8th date, we can just have, even if it's an email that's under penalty of perjury from Miss Rosen about how the reunification process has gone.
Absolutely.
And essentially, I do think, and this is assuming that everything comes back. And the reason why I'm leaning towards assuming that everything is going to come back with Miss Erickson being an appropriate parent is because of, frankly, the comments about the child, that she's clean, well-behaved, appropriate, smart, all of those things. So assuming everything comes back, then I'm looking at pretty close to a 50-50 parenting plan at that point. And that's not to take the child away from everyone. That's to benefit the child to have access to both parents and nurturing from both parents and understanding that, frankly, that's where I'd love to see most parenting plans end up. But I don't want to, I don't want to do that at this point without some of that information. And I understand that petitioner's position is that Miss Erickson had plenty of time to provide those things. But given the comments that I've heard about the child and the child's behavior, I don't see just removing the child completely from mom is appropriate at this point. Okay. So to be very clear, Miss Erickson, you're going to continue following reunification with Miss Rosen. However, and if she says, okay, this weekend, Ellie goes with dad Friday and comes home Sunday, that means that Ellie goes with dad Friday to Sunday. Okay. If that means, oh, this weekend it's in, overnights, Saturday at noon to Sunday at noon, then that's whatever she says is what it
Absolutely.
is. If it's, a, 4-hour visit one day and a 6-hour visit the other day, then that's what it is. So Miss Rosen will lead that therapy, and I will,
I thank you for that.
I assume that Miss Rosen's, education experience, she's someone that's well known to the court, that her education experience, knowledge, and in best interest of the child is going to lead that reunification. So whatever she says goes as far as how that process works out.
Thank you.
And it will frankly weigh pretty heavily with the court once we see how, she did indicate in her testimony that we're looking at getting close to overnights and even longer. I think was 6 hours the longest so far, or 4 hours?
I think it was 3 hours.
3 hours. Okay. That it was, I think, maybe doubling or something. So we're amping up here. And she did indicate it was progressing rather quickly. My hope is, all those things, and frankly, Miss Erickson, if we're in a situation where none of this stuff is filed by the 8th, and because you're no longer represented, you can contact Miss Winkles and just say, hey, look, this is the problem I'm running into. I don't know how to solve this. She may be able to offer some assistance into like directing you how to get the information that we need.
Yes, I don't.
So you can contact her. I'm not suggesting that she doesn't necessarily have to do that, but I think she clearly is invested in this case and Mr. Anderson and the child. And I think we all want what is in the best interest of the child. So because you're not represented, you can contact her if you run into any issues, just at least so she gets a heads up. I think more communication is better. Like, I'm running into this problem. I want you to know about it,
Or even just doing a conference call with the provider for the release of information. If that comes necessary, I don't mind doing any of that.
Okay. Thank
Okay.
you.
And then on December 19th, I'm going to assume that Miss Winkles will be at that point proposing a parenting plan that likely will be in line with what her and her client think is appropriate based on the information we have by the 8th.
Perfect.
That makes sense.
Okay.
And Miss Erickson, you are also more than willing, or excuse me, more than able, if you wish, to file your own proposed parenting plan with the court about what you think is best, because that information from Miss Rosen will also go to you. So if Miss Winkles gets a report from Miss Rosen, you're gonna get that report too. So everybody will know what's happening with those with the meetings between Mr. Anderson and your daughter. Okay. I understand that this is sort of again, there's no definitive answer for Mr. Anderson, and this has been a long process for him, but I think we are very close to getting a parenting plan that I hope will work and be in the best interest for this child. And I just want to, again, I made a very big note with a whole bunch of asterisks on my page here that both parents' faces when speaking about the child, it warmed my heart, to be very frank. Watching Miss Erickson hear Mr. Anderson talk about their daughter. That's what I want you guys to focus on. Not the history, not the issues. Even this chaotic, toxic relationship made this great little person that you need to support moving forward. Okay. So change can happen, change can be positive, and we have to believe that we can change. Okay. So, any questions about what we need to do?
No, and just so everybody's aware, I have zero. This is kind of like my baby of a case. So anything that I could do to facilitate anything here, my office you can call my office and I'd be more than happy to facilitate anything that helps this to get solved.
Okay, so to me, Miss Erickson, that means if you run into any issues, contact Miss Winkles. It sounds like she's willing to help because I think she wants a resolution for this case that works for everyone. Last thing, Miss Winkles, I do have the stipulation about exhibits. Do you want those returned or destroyed?
Destroyed.
All right. Is it okay if I indicate?
Can I keep the
via
binder
Zoom?
though? Yeah, via Zoom.
We'll get
is
you the
fine.
binder back. Yes.
Yeah, those things are like $15 each.
You need to use smaller ones. And Miss Erickson, you didn't have anything, so I'm not going to indicate anything for you on that order. It's just basically what parties want the clerks to do with any exhibits that they've provided. So that's why I asked.
Okay.
All right, so I look forward to getting information on December 8th and seeing everyone on Tuesday, the 19th of December at 1:00 p.m.
All right, and I'll have orders to your honor. Should we do a presentation or?
If you want to put one on before then, the only thing is I will not be
When
on the
are you
docket
here?
I'm not on the docket the 21st of November. I'm out of the office that day, but otherwise, and I think the 31st may be closed at this point. So
It is.
I
I'll
also
do
have
that.
I have Fridays at 8:45 as well if we need it.
Okay, I can do the Friday at 8:45 and just, and we might just be able to sign off on it because I should be able to get it exactly how you've said it today. So hopefully we'll not even need it.
Okay. All right. I
All right.
appreciate everybody's time. Keep up the work and we'll see you back here December 19th.
All right. Thank you, Your Honor.
All right. Good luck.
Bye-bye.
And we can. All right. Since Ms. Winkles, I put you on the spot there, we'll go back to the Anderson and Erickson matters 21-500-7308 and 23-300-1508. And it does look like we have Ms. Erickson present now. So as to the 21-7308 matter, this is looks like the presentation of final order on a parentage determination. Just make sure I have the right numbers with the right things here. Ms. Erickson, did you receive the proposed orders from Ms. Winkles?
No, I have not. I haven't gotten any. I didn't even know about this. I thought we had court on the 19th.
And Your Honor, if I may, we've been talking via email. I sent it to the same email that she responded to me this morning on. I sent all the documents.
I haven't seen it.
Okay, hold on.
And we also mailed them to her.
I haven't gotten them. But sorry, I was late on here too. I literally had no idea where I was supposed to go. And I guess I was sitting in the wrong Zoom.
All right, I do show that on the 19th, we have a review hearing for the 23-1508 matter.
And that's with all my stuff, right? That I was supposed to.
And then I have this, well, it was set on, it was on for Friday morning, December 8th. I was ill. So they set it to today's docket, the 12th. The 8th was set for presentation, is my understanding.
That's correct.
And we have final orders of the parental determination. So that's in the 21.
I was going to submit I seriously thought that we had this court hearing was supposed to be the 19th, and I was going to submit a parenting schedule thing because you mentioned to me that I could do that, and then I finally am able to get help. And since I don't have an attorney, since he like completely bailed on me, I'm seriously lost. And I haven't felt comfortable enough to really talk with Erin Winkles except for when I was dropping off papers. I asked a few questions, but I didn't feel comfortable asking certain questions.
I can understand that this is probably an overwhelming process, and without legal help, it can be very daunting, and I appreciate that. I can't give you legal advice. Ms. Winkles can talk to you directly about some of this because you are unrepresented. We have, there was a
I'm
summary.
trying.
I'm still talking. There was a summary judgment granted on January 13th, 2023 in the 21-50007-308 matter. Then that was amended due to a Scrivener's error and re-entered, I think, in October of this year. So we're working off of essentially in this matter, and Ms. Winkles, please correct me if I'm wrong, but essentially just a final parentage order that we need to get entered because of that summary judgment that was frankly entered almost a year ago. Is that correct?
And it should have been entered after, and I'm not sure if it wasn't attached or if it's floating around the court still. But we just submitted it again, essentially the final order. So it wasn't just the, the MSJ order, which is kind of temporary in its way.
All right.
My daughter doesn't really know Aaron, like they're getting to know each other through reunification still.
This basically is an order that says that he's the father.
Oh, okay. I'm sorry. I don't understand anything. I'm sorry.
So as far as that matter goes, this is, I think, probably was just an oversight. I am going to enter the order in the 21-50007-308, the essentially a final parentage order indicating that he is the biological father.
And Your Honor, can we also make sure that Ms. Erickson knows exactly what the 19th is so we don't have to continue or have any other issues with what's going on then?
I'm sorry. I don't mean to.
It should be the entry of final orders after you review whether or not Ms. Erickson has a collateralized mental health evaluation and a drug hair follicle. And then you were going to determine custody at that time for the final parenting plan.
Okay, so because it's that case that's on the 19th is also on today. That's the 23-30001-508 matter.
And I thought it was actually for today. I didn't know we were on the 19th, so I thought it was all going to be today. But I'm fine with however Your Honor wants to do it.
I called this the court clerk, and they told me the 19th. So like I said, I was trying to get in something that my attorney, I kept asking him to do and he wasn't doing, if that makes sense. And I'm trying to get our $5,000 back to try to find someone to help me on top of everything else.
All right. So we had, long story short, this is my version of my recollection of what occurred. We had a bench trial back in October. And at that point, you were representing yourself. Ms. Winkles was representing Mr. Anderson. There was a lot of information provided by Mr. Anderson, not a lot of information provided by you, Ms. Erickson. The court, and it looks like I was the trial judge, the court allowed some leeway to basically get an evaluation.
Yes.
That the court has not received. And I believe I set a date.
I gave it to Miss Winkles on Friday. I was trying to,
and that's
I was hoping.
And that's what I explained, that it's not, and you'll see my emails behind my declaration, Your Honor, that I've submitted to the court. I told Ms. Erickson that was not an evaluation. It was not collateralized. And I explained exactly who to call.
Hey, Ms. Erickson.
Sorry. I'm
sorry. Stop talking over people. No one can hear anything. We've gone through this before. One at a time, please. When someone else is talking, please don't speak. I'll give you an opportunity. I give everyone an opportunity. So please hold on. Ms. Winkles, go ahead.
Yeah, so Ms. Erickson did sign an ROI so that I could talk to her counselor. I did speak to him and he told me that it was an intake and it was not an evaluation. So he hadn't seen her for some months. So she came into the office and I informed her of that. I said, all you need to do is you need to call them give them, Mr. Anderson's number, they will collateralize and they'll do an evaluation. You need to contact them today. I sent her 3 emails as well, telling her that it was not an evaluation. She did not have an evaluation, but she could get one through either Columbia Wellness or Core Health, and that Columbia Wellness would assist her as long as she called within 24 hours. And that's where I left it. I assumed I would get something. I did not get anything, and my client's not been called as of today. So I'm guessing one has not been done. The intake was from last year, I believe, or the beginning of this year.
All right. So since our trial on the 26th of October, Miss Winkles, and I'm not seeing anything in the in Odyssey, but that doesn't mean you didn't receive something. Have you received anything from Miss Erickson regarding a 10-panel hair follicle or a collateralized assessment between October 26, 2023 and today?
So no to the collateral assessment, but I did receive a sheet showing that she had taken a hair follicle. I don't know if, because it was so close to today's date, I don't know if they have the results of that yet. I can actually look because I can log into my system. But the evaluation, no.
All right. And my notes indicate, I'm talking now, Miss Erickson.
I'm sorry.
My notes indicated that all of that needed to be provided no later than December 8th at 5 p.m. Do you show anything different, Miss Winkles?
No, that's what I showed as well. And I actually submitted a proposed order to the court from that hearing that stated the same thing.
All right. So Miss Erickson, it sounds like
May I explain?
I'm asking you a question. My understanding, based on my review of everything, was that you needed to do at least those 2 things: get a collateralized evaluation and a 10-panel hair follicle between October 26th and December 8th. And I don't know either of those things. So please tell me why.
Okay, so so the reason why I have them right here in my hands, I honestly thought that I was supposed to give Erin Winkles hers by the end of her closing time at 5 p.m. And it was already later because what happened was I misplaced, because I already had those done and I gave them to Mr. Roberts. And he was supposed to turn in everything. Come to find out, he turned in nothing at all. So I had copies of it, and all of a sudden I can't find it, right? So I had to actually go to Columbia Wellness myself, and I went and sat there and while we reprinted off the evaluations and stuff, and one of these pages actually looks a lot different than what I was actually given on my other paperwork, to be honest. They say assessment, and I'm confused because Mrs. Winkles is telling me that, because I did my evaluations as far as I was concerned, and I guess the assessment or whatever isn't it, even though I was told that I did it. I'm so confused over that. But the reason I was going to do my parenting plan, I was getting help because you told me that I could submit one, and I didn't know I could. And I've been waiting and waiting, trying to get help through Northwest Justice and everybody. And I was going to turn everything in today before you guys closed. That was my whole plan. And I thought that we honestly had court on the 19th. I didn't, and I was confused when Miss Winkles, sorry, excuse me. I was confused when she told me, because I gave her a copy of the hair follicle receipt. They didn't have a 10-panel, so I chose to do a 17-panel to kind of go above and beyond and prove that I've been honest. And that should be emailed to Miss Winkles. It should have already been emailed because they said it takes up to 24 hours. And that should have already been done. They wouldn't give it to me directly.
even though we're the ones that like my dad paid the $350 for. But so I had him sent to, I didn't know how to send them to the courts or how to. So I sent them to Miss Winkles in hopes that she would be able to, maybe direct me in some sort of way. Like, that's why I was going to ask her. And then they started looking at my babies, and I just kind of we were talking about my two girls, and I completely
do have the
spaced out.
negative. Just so you're all aware, I do pull it up now. She is negative on everything on the hair panel.
Thank you. I knew. Yep. I have almost 6 years clean and sober. So, okay. So, and then with the parenting plan, I've never done one before, ever. And, that's why I was reaching out for help. I requested that Mr. Roberts help me get one in instead of just agreeing and everything. And he kept telling me, no, we're not going to, that's not what we're doing right now. No, that's not what we're doing right now. And until he told me on September, literally on my daughter's birthday, September 19th, that he was no longer going to be my attorney. It is the day that he told me. And then that's when I found out at trial that he never turned in anything that I had submitted him. I gave him everything. I gave him all the copies that I had. I didn't have any copies for myself, and that was stupid of me. But I trusted that he was going to put those in, if that makes sense. And I kind of fooled myself. But I have the paperwork from Columbia Wellness. It's right in front of me. I was just needing help with the parenting plan since I wanted to do one, and he told me that it wasn't the time. Or I have all of his text messages saved.
Okay. I again appreciate the difficulties of navigating this without an attorney, and especially I do recognize that you were at one point represented, and that in September of this year that attorney withdrew, and we did have a trial in October. But I do want to stress that we already had a trial, so there's we can't have several bites at the apple. I gave an opportunity for you to get this information in. I asked that it be turned in by the 8th. It sounds like you have all that information now. We are currently set on the 19th for review. Miss Winkles, it sounds like, received the hair follicle, and that was clean. So that is great news. So thank you, Miss Erickson, for that. Yeah. I'm not 100% clear that we are where we need to be for that collateralized evaluation. So my understanding, based on the information that Ms. Winkles provided to the court, is that you did an intake, but you didn't do an evaluation. Intakes are not collateralized, meaning they don't get any information from anybody else about an intake. But once they actually do an assessment or an evaluation, that's when they can have collateralized information.
No, I have the assessment right in front of me. I'm sorry.
Well, if it still wouldn't be valid if other parties weren't able to weigh in on it, because that's what was ordered.
Oh no, Aaron's been in there, both of them. I've had them on collateral this entire time.
Miss Winkles, did your client?
No. So this is not true. I spoke to.
He's supposed to call.
Wait, it's one at a time.
Sorry.
Okay.
I'm sorry.
So I spoke to Mr. Sandecker, I believe was his name, who is the person that did it. He stated he hasn't seen her in months, and when she came in, she only did an intake, which everybody does. He stated that she had not done an evaluation at all, and that it had not been collateralized because it was just an intake. And that's what I told her. I even handed her the phone back, and I said, "This is an intake. It's not a drug evaluation. You still have time, though. If you call him on the phone and you ask him to do the evaluation, I've just spoken to him on the phone. He's willing to do it. And that was about, I don't know, about a week ago.
That was how long ago? I'm sorry.
About a week ago, I'd say.
Okay. All right.
It was Friday or Thursday.
He-
I've been speaking.
Here's the
with my
problem. I'm
counselor.
done right now. Here's the problem.
I'm sorry.
We're
I'm sorry.
it sounds like you're doing what you need to do, but you're doing it at the very last possible moment, and frankly, after the deadline. And I don't have this evaluation. I'm going to absolutely take Miss Winkle's word for it that the hair
I
panel.
promise you I have
I'm
it.
talking right now.
I'm sorry.
We don't, but we had trial on the 26th. All this stuff was due last week. We are on for a review on the 19th. This stuff needs to be into the court and filed and provided to Miss Winkles by the end of today. So by close of business, the clerk's office closes at 4:30 p.m. I would suggest you hang up the phone and immediately come over to the clerk's office, file whatever you have, make sure that Miss Winkles receives it. We're going to be back next Tuesday, the 19th at 1 p.m. to review this case. If I don't have what I asked for 2 months ago, I'm likely going to enter the orders that are presented by Ms. Winkles. She provided proof of service to you. You're claiming you didn't get that stuff.
No.
I would reach out to Ms. Winkles and make sure that you get copies of everything. But it does appear to the court that you've been provided all this information. So
yeah, no. May I ask a question real fast before
yes.
I annoy you? I'm not trying to.
You're
I'm
not
nervous.
annoying me. Go ahead.
Okay, I'm sorry. I'm trying not to cry. Sorry, it's emotional. My daughter. Okay, so my SUD and my mental health right here, I'm looking at them right now. Okay, they say assessments on them. They were not intakes, they were assessments. And I gave her the same paperwork that I have right here that I'm going to give to you guys. Do I have to reprint them off and give them to her again? Because I'm confused on that.
I think you can, if you can confirm that you have the same things that you already gave her and that's what you're filing,
Yes.
you don't have to give them to her again. But if you have something that she's saying she doesn't have, then you need to make sure that she gets a copy.
Okay, yeah, they Columbia Wellness helped me separate everything for you guys and her. And everything is the same.
Okay. So that needs to be filed so I can review it prior to our review hearing next. And it's going to be a presentation hearing. And that includes any proposed parenting plan that you wish to file. Okay.
Okay. I'm in Oregon City right now, so I definitely have to get a move on it. So.
All right. Good luck.
Thank you so much.
All right. We'll see that. And I'll, Ms. Winkles, I'll ask the clerk to hold these papers until next week.
All
right. Anderson and Erickson, 233-0001508.
That matter's ready, Your Honor.
All right. And I see Miss Erickson present. And
I'm trying to make a bottle. I'm sorry.
Okay. I have we were here last week and on the 12th, and I set this over 1 week to allow some information to be filed by Miss Erickson, and told her she needed to do that by the close of business on the 12th. Nothing has been filed.
I filed things. What? Nothing's been filed. I filed things. I filed everything in there. I filed everything. How is that even possible?
And so, Your Honor, just so you're aware of what
how is that possible?
I'm guessing what she filed. We did receive a mental health evaluation from May. It was the original one that I think that we were kind of aware of, but we hadn't seen. It was not collateralized. It's just Miss Erickson, her evaluation. There's no collateral contact with the GAL or my client or anything. It was the initial one that we hadn't seen, but the GAL said at the time, this is not collateralized. We need it collateralized. It was by that same contact that I had informed Miss Erickson that he would discuss it with her if she called him back. We did also get the hair follicle back. It was negative for everything, including Suboxone. which was really kind of shocking considering Miss Erickson claims that she's on 16 milligrams of Suboxone a day. So this is the second hair follicle that was negative for Suboxone as well. I believe Miss Erickson's argument was that her body's used to it, but that's not how it works. It still shows up. Buprenorphine still shows up in your hair, unless there are those shampoos, I guess, that you can get to remove it, but they remove everything. So I am a bit concerned about that. At this point, I'd ask that either my parenting plans be entered as they are, the final orders, Ms. Erickson has received those, or that if we're going to do any sort of joint schedule, that my client maintain all decision-making ability, because there's been non-compliance the entire time. We had to go through so many contempts, so many things just to get here, that I am concerned that my client will be back in court next week, the week after, the week after. It's just not going to work. Miss Langford's here as well, the GAL. I know she's been discharged, but I'd ask the court to maybe weigh in with her. We've already had a trial on this. Miss Erickson has had every opportunity to get these things collateralized. This is not her first go round. She has had 3 other cases with other children where she was asked to get collateralized mental health evaluations. She didn't in those cases either. This is, there's only so much we can do. I've tried to be incredibly helpful. I called, her counselor. I said, this is what we need. He said, fine, have her call me. I told her, call him, he can help you out. To the best of my knowledge, I've received nothing that's collateralized. This is from May of this year. It's no changes. There's nothing that the court is very specific on. We want collateralized evaluation. You have to get this updated. It's easy. I just fear that nothing will be done as it should be. It'll all approximate something without going that extra level if we don't have my client have joint or sole decision making to everything.
Madam Clerk, do you show anything filed? I don't have anything. I have things that were filed after the 12th, but those were all filed by Miss Winkles. Are you showing anything that was filed that hasn't been scanned in, or?
Odyssey's loading, hold on.
I'm sorry, this is really odd. I filed them. I packed the baby up in the baby carrier and everything, and with my 4-year-old, we filed them.
So there's nothing new in Odyssey unless maybe she filed it this morning.
I put my whole entire life.
Or if there were issues and it got rejected, but they would have called her.
Yeah, and I followed a parenting plan too, which is odd. I did everything that I was supposed to.
Well, I want to remind you, you did everything you were supposed to 2 months later than you were supposed to, but
I know, I'm sorry. I do apologize with that. I was behind.
Well, that's part of the problem, Miss Erickson. I understand again how difficult this process is for somebody that's not represented. But we had a trial on this matter on the 26th of October. I gave you almost 2 months to get everything filed, and there's still absolutely nothing in the file. Absolutely nothing. And that doesn't work for me. I don't know how much more.
May I say something?
I'm talking, and when you keep interrupting me, I can't tell you how frustrating that is. I've had that conversation with you so many times. I don't interrupt you. Please don't interrupt me. Okay. I can't tell you how difficult it is understanding the difficulties of navigating this the judicial system for this case. I don't know how much more accommodating the court can be, frankly. We had a trial. I could have made a ruling that very day, and I gave you an opportunity to provide information to the court. And I'm here 2 months later, and I have nothing. And I have information that Ms. Winkles filed where she was trying to help you file this information and show you how to do that. It's email exchanges, you and back and forth that she's filed with me, telling you exactly what you need to do, and I still have nothing. So I am happy to hear from you. Please let me know why you have done nothing.
I have done everything. She has taken, okay, I'm confused because when Scott Roberts was a part of when he was my attorney, he told me that
she had taken out everything that I had put into the courts because of some kind of like, it was when I was at the doctor's or whatever. And supposedly like something happened and we weren't supposed to be able to tell you about it, about his criminal history, about the DV. Apparently I wasn't supposed to speak of any of it. That's what Scott Roberts told me. So I had to
Does
sit
that
there
have to do
quietly
with
about
the
that.
report and the parenting plan and any of that?
And then with that, Scott Roberts, I gave him everything. I seen him on here earlier and it kind of irritated me. I gave him everything to turn in. He said he turned it in. He even gave me a declaration that he wrote out and he said he turned it in. Nothing had been turned in and I'm just now finding that out. And I apologize. I can get everything else back in. If I can be given at least a few days, I can. I've raised my child on my own. This is just crazy to me. Like, Erin wants to come into her life when she's 3.5 years old. That's fine. That's fine. But please don't take her from me. Like, I've been trying to do everything I can. I did a parenting plan on my own. I did the law help one where they helped me do it, like step by step. I thought that was pretty cool because I didn't know that they did that. Requesting for him to have first, third weekends of the month and every other Wednesday. I just don't understand how none of them are in there. Like, I have turned them in. I put my entire life on that. Like, I'm really, really baffled and kind of confused, and I don't understand any of this. Like, it's a bad dream.
And Your Honor, if I might, even if she turned those in, they're still not compliant. As I told her, that's from May of this year. It was not collateralized. None of it's collateralized.
It was
Your Honor
collateralized.
said, I have that in my office. I can send it to the court and the parties. It was not collateralized. My client was never contacted. Miss Langford was never contacted, which is why she got the other email saying, you need to call. This is not collateralized. The court's very clear. It needs to be updated. So I'm not sure where to go. We were more than willing to try to do everything we could, but if we don't have the information, I'm not sure where to go from here. So I'd leave it in Your Honor's hands.
All right, Miss Erickson, now you can talk. Please let people speak and then speak. Go ahead.
I'm sorry. It's just, it angers me because that's not true. So when I went to Columbia Wellness to get the paperwork for you, what was it, a few weeks ago, to get my assessments, because she said they weren't assessments, they were, what did she say they were? Intakes? But they clearly state assessment and they were highlighted there. The lady highlighted it for her. And then that's the reason why it took a little bit longer to get to you, because, well, it should be in there anyways, because I had to go all the way back to Columbia Wellness because the Superior Court wouldn't take it with the highlighter on it. And I didn't know that. And I was speaking with the lady and I was just basically rambling like I am now and venting because I have nobody else to vent to about the situation. And she goes, well, that's funny because I had spoke to Mr. Anderson on the phone about this. He continuously tried to push that they are to contact him for collateral. And numerous times has he been told, and so has his attorney. My counselor even told his attorney. He told me this, that no, you are to call. The ROIs have been signed since beginning, have been signed. They've been done. All they needed to do was call. That was my fault for not telling them Columbia Wellness, because I initially at the time thought they knew it, because that's what Vashti told me was Columbia Wellness is where you get it done. I just had the baby, so I was kind of going through a lot, you know, and then plus having threats of my baby being taken from me when I raised her on my own. Anyways, I was like, really? And then she continued to say that she actually had to send him to one of the bigger bosses, and I think his name's Chris or something like that. And Erin continuously argued, trying to make that man say that no, we're to contact you. You're right. And he said, no, they told him that, the ROI has been done. You contact, and they've contact. I was told by that lady, and it showed in my account. Supposedly, that's what she said, was that they have already contacted over my assessments and stuff. So I am that's why I'm getting upset, because I'm extremely concerned on why people are lying so much. Like, I don't understand it. I have to be honest. And then receiving something about my child's doctor when I had already in the beginning, even Vashti knows that she goes to, not to child and adolescent. Like, where did that come from? Like, all this stuff that they're throwing at me when there's not supposed to be abusive litigation, that's said on my thing, on my protection order. It is stated by Mary Hahn, because that's exactly what he does. And that's why I'm upset. I'm trying to calm down. I'm sorry. This is what Aaron does. It's just like, it's been one thing after another after another. I've done what I was supposed to do. I thought Scott Roberts did what he was supposed to do. He took $5,000 from us, and we worked hard for that. I don't have that. You know, I can't afford that for another attorney to show that I'm being honest. So I'm trying to use my voice, and it's so hard to do this right now. But everything that has came out from Ms. Winkle and Mr. Anderson is just completely baffling. It's not even true. Like, I don't even understand it. Like, why? My child goes to Vancouver Clinic. She has since I gave birth to her, you know, like.
Okay.
I'm so sorry.
Couple different, thank you, Miss Erickson. I understand your frustration. The clerk asked of, she's in the courtroom. She asked of the folks in the office if there was paperwork filed. They indicated that there was paperwork filed, but they weren't, or brought in. They were not filed because they all have the wrong cause number on them. So I asked if they could be brought to me, and that's what I just received. I obviously have not reviewed them. They all have the incorrect cause number on them, the parenting plan, and it looks like some healthcare records. Is that what you received, Ms. Winkles?
It is, Your Honor. And just so you're aware, Miss Langford has her hand up. I'm not sure if you can see that.
No, I did not see that. Ms. Langford, if you want to jump in here, by all means, go ahead and make your comment.
Yes, I'm sorry. I don't have camera ability. I'm at OHSU, where I've been pretty much every day since Thanksgiving. So I just want to clarify some things. I've never, ever received confirmation that I am on RI for Columbia Wellness, as it states in my report. I've called, and they keep telling me the same thing, that I'm not on the RI. I've reminded Miss Erickson I need to be on there for collateral. I've not received any documentation from her since way prior to the hearing or to the trial. I still have not been contacted for any additional assessment since the one we've seen in May. Her attorney actually asked me for documentations and said he had nothing from her prior to him removing himself from the case. I gave him what I had. And I'm honestly probably equally frustrated, because I've given reminders that this needs to happen, this needs to be done prior to the trial. And honestly, I have medical things with my family to deal with, and having to be dragged back and forth because we're still not getting what we need is very frustrating for me. Because I want what's best for the child, and we're not able to do that right now because we're not getting what we need. And I've not received anything from Mrs. Erickson since way prior to the actual trial that we had.
And I appreciate that, Ms. Langford. Can I just ask a follow-up question? I know that you were present at the trial that we held back in October of this year, and at that point made recommendations. Is anything about the recommendations you made at trial back in October, has anything changed, I guess?
No, I think that I would at this point I would agree with anything that you're recommending, because we're just not getting what we need to verify any information, and we're all coming back to the same courtroom for the same responses, and we can't say what's best for the child. We don't have all the information, which is what we're not getting.
All right, I appreciate that. Thank you. Okay.
May I say something? I can pull it up on my phone even. Vashti has been in there since I did it all at the same time. Why wouldn't I? I did. I told her, I even have an email from Vashti that said, I was like, what else do I need? And she said she had everything from me. I have that in an email. I can, if I could send it over to you right now, I would. And I should have printed it out. I had a feeling to print it out, but I've been having to use my boyfriend's work because he's a mechanic and we don't have a printer in the apartment. So I've been trying to, find out ways of getting you those documents. I swear I have put all my ROIs in. That was my major deal. Like, that's a huge deal. Why wouldn't I? Like, that's my baby. I don't understand what's going on. It's like a really bad dream right now. Like, really, really, really bad. Because if I could get you everything, I'll give you all my whole profile. It shows exactly the dates when I put those ROIs in. It shows the dates and the times. And they have been in there since way before May. And I'm sorry to overtalk. That's why I needed an attorney, because I don't understand a lot of this stuff. But I need them for my boys, because I'm not good at what I'm sorry, my 11-year-old's bugging me. Lexi, go sit down, please.
All right. Here's where I'm at. I kind of echo Miss Langford's comments, because I feel like even though we went through a trial, there wasn't a lot of information at the time. Mr. Anderson hadn't even, I don't believe, started any kind of weekend visitations. And I believe that we were progressing towards those with the help of Miss Rosen and her working with the child here. And but at some point I feel, I do agree with Miss Erickson that this is kind of like a bad dream, because I feel like it's the same issues repeatedly over and over again. I'm reviewing my notes and I'm reviewing the minutes from the trial, and very specifically, there was a discussion with Miss Erickson that she needed to sign ROIs because those had not been done, and that the mental health evaluation that was done prior this year would not be appropriate because it was already at that point over 5 months old, and a new evaluation would need to be done that was collateralized. We've done nothing. So we haven't even been able to do that.
I'm gonna be complete. I'm gonna be honest.
I'm gonna talk. So I don't know if Miss Erickson just chose to zone out when the court was making the rulings back in October.
I didn't hear
but
it.
all of the I'm muting you because you keep interrupting me. So please don't unmute unless it's your turn to speak. Very, very clearly in my notes, in the minutes, it was discussed that release of information need to be signed for all the parties so they can all be contacted for input. And it sounds like the only thing that she's done is the hair follicle, which is great. And I'm glad that that came back clean. I agree with Ms. Winkles. There is some concerns if she's claiming she's on a Suboxone program and it's not even showing that. That is a concern. That doesn't just, I get immune to a Suboxone, so it's not in my hair. That's not how that works. And she did inquire of the court whether she could file a proposed parenting plan. I said, well, you can always file a proposed parenting plan. So now I just now received that after asking the clerks to have it brought back to me, even though it's under the completely wrong cause number. So I feel like I'm extremely frustrated. I don't want to suggest at this point that Miss Erickson is a bad person, a bad mother, but I do find that there's some definite concerns about what her cooperation level would be like on any kind of parenting plan with Mr. Anderson. She claims that she wants Mr. Anderson to have visitation and to do all that. But I'm just concerned whether how that would go. Her proposed parenting plan, and Ms. Winkles, you indicated that you did have this copy, so that's why I'm referring to it. Basically says that he has to comply with treatment and that he would get the first and third weekends of the month. And that's school age and non-school age. And that's pretty much it. Your proposed parenting plan.
I meant to put Wednesdays on there. I redid another one and it deleted completely. I'm sorry.
Your proposed parenting plan basically has, I mean, it's the extreme in the other direction that,
it is a phased in approach. It's an extreme until she gets the collateral mental health. And I believe it moves to more of what your honor was talking about in the trial, the 50-50, but without that collateralized mental health, we had it the extreme. We had 2 actually filed.
We've had weekends with Dad.
Yeah, yes, he's had overnights. I believe he just had the last weekend.
I did have my overnight this last Saturday.
All right. So, I do recall, we just have layers. I understand Miss Erickson probably is a stressed out single parent. I know that this is not her only child. I know there's a lot going on, and this, it's hard to prioritize things, but obviously this was a pretty major situation. I have proposed orders that Ms. Winkles has provided. What I'd like to have happen is so I'm gonna adopt the orders. There's one thing I'm gonna take out the 191 of substance abuse as it relates to Miss Erickson in the proposed parenting plan. She's a clean hair follicle. There was a history, but her claim is that she's been clean for I believe she said 6 years. So great. I'm gonna take that out of the mix here. So I'm gonna sign this parenting plan. So what that means, Miss Erickson, is you're gonna have visitation with your child until you get that that evaluation done. And then once that evaluation is done and it's collateralized, then my hope is that we'll move to a 50-50 parenting plan. But you have to get that evaluation done. It has to be collateralized. That includes Miss Langford, Miss Winkles, Mr. Anderson. Those people have to have that information. Once that information is provided to the court, then we'll have another hearing and adjust the parenting plan based on that. Is there a visitation that was scheduled for this weekend? Or when was there another
We were
visitation
going by
scheduled?
Charlotte. We were going by Charlotte.
Mr. Anderson, was there one for this weekend?
We were waiting for what the court hearing was going, and Charlotte wanted me to contact her after the.
All Ellie knows is
knows everything.
you're hurting my child.
I hope I'm not hurting your child, ma'am, but I can't.
No, not you, not you,
about-
not you, not. I wasn't talking about you. I wasn't talking about you. I was because he was speaking, and I'm just saying that because he never tried until I got pregnant. So it's like I raised my baby on my own.
I'm not suggesting that you haven't put the work in, but there's concerns here that have been raised by multiple individuals.
I really
There's
didn't hear
multiple
the.
things going on. There was a.
I had the baby, and I was going through. I went through postpartum.
I'm done at this point. I can't argue over the top of you. I've made it known in several court dates what's been requested of you. I've tried to give you ample opportunities to get that done. I, again, am not in any way indicating that you're a bad person or a bad mother, but there are things that the court's ordered that you've basically just ignored. So we have a healthy relationship that's been established between father and child. And my hope is we'll get to a 50-50 plan, hopefully within the next few months. And this is a temporary situation that we're in. But I'm going to indicate, and there is an indication on here that once that evaluation is done and that there is, you're going to have 60 days to get that evaluation done. That doesn't mean the report has to be done in 60 days. That means it needs to be set up and
it's just minimum.
Let me rephrase that. Doesn't mean the actual evaluation, like the final report from the provider needs to be done in 60 days, but the appointment has to be done and made within 60 days.
I'll do it.
And then I'm just going to indicate in here.
Please.
I want to make sure, Ms. Winkles, and please point it out to me if it's in here already that that this, and I don't know if you want to just set a review date or that Ms. Erickson can bring it back for reconsideration once that evaluation is done.
I believe it says that she can motion the court the moment it's done, but if I haven't put it in there, that's what I would suggest, just so we don't come back and it's still missing and it looks bad. Maybe as soon as she gets done, if it's done in a week, if it's done in 3 weeks, however long it takes, she can just stick a motion in the court and we can come back. I thought I had it at the end of the evaluation part that she has to do it in 60 days and then she can motion the court. Otherwise it stays the same. But I've done so many parenting plans for this case. I'll be honest with you.
Right.
I can't remember.
It does say, okay, so Ms. Erickson, listen very carefully. It says after obtaining the relevant evaluation, you can petition the court. And I'm going to say petition the court, and it says to begin weekend visitation. And here's what I'm going to do. I'm going to change the language here. So after obtaining the relevant evaluation, the mother, and this is going to basically be an agreement between Miss Erickson and Miss Winkles. The mother may.
Can I get my custody back?
Can you hold on?
Is there a way to do that?
The mother may begin weekend visitation. So evaluation's done, mother starts weekend visitation. Once the evaluation is done and all the parties have received the report, then mother may petition the court for a change in the parenting plan without an adequate cause finding. So what that means is that once we have the evaluation, everybody's seen the evaluation and been able to weigh in on the evaluation, you come back to court and then we look at the parenting plan and decide what is best moving forward. Once we have that information. Once you've done the evaluation, your weekend visitation would start. Does that make sense? Okay.
So
I
after
have-
acknowledging, sorry,
Go ahead and ask the question, Ms. Erickson.
I'm so sorry.
Don't apologize.
After I do the collateral, yeah, I don't have money for an attorney because that man stole our money. I don't know what to do. I raised her. Like, when can I get her home? That is my baby. It's our baby.
It's
But
exactly,
he just now came into the picture.
I understand that, and that's why we're dealing with this. So I'm not ordering any fees, so I'm striking any judgment as requested, so I'm not imposing any fees. And okay, I'm gonna mute you again here, and we need to keep our record. See here, there's a child support order in place. Ms. Winkles, I'm gonna table the child support order, and after
That's fine.
60 days, if there's nothing, then I'm gonna enter the child support order. Is that fair?
That's absolutely fine. And Your Honor, just so you're aware, we'd be okay with her filing just a motion rather than a petition. Just because I believe since she's pro se, my client doesn't, he wants to be easy, but he wants to have the information is really where we're at. So we're fine with a motion rather than the full petition, because that might be a little bit more confusing for somebody who's pro se.
Okay.
I don't even understand any of that right now. I'm sorry, I don't. My brain's just.
I understand that, Ms. Erickson. I would remind you, and I'm assuming, Ms. Winkles, you're gonna stay on in this case.
I am, Your Honor.
Everything that Ms. Winkles has filed that about your interactions have done nothing but indicate to at least me that she's trying to help both of you through this process. So if you have a question, based on what Ms. Winkles has indicated thus far, I think she would be willing to at least try to answer those questions for you. She can't obviously represent both of you, but I've changed that to may motion the court. So that means you just say, I need to have a hearing in front of the judge about my parenting plan. That's, and you come in and the clerk will help you and you file that. Make sure it's on the right cause number, and so you know that we're under the cause number of 2331508. The child support orders I am going to set aside, so I'm not ordering any child support at this point. After 60 days, Ms. Erickson, I want you to be very clear. If you don't do anything after 60 days, then this is just going to be the order. Okay.
Yeah, that's not possible. And I'm gonna make sure that I'll put 3 copies in, and if anybody takes it out, then I don't know what else to say.
I'm glad to hear that. And again, once you get that process started, it sounds like Ms. Winkles will help you ensure that everybody's on there, everybody's doing what they need to do.
I can't trust her. I'm sorry.
Okay, well then do it on your own, I guess.
No, I need help.
I don't know. I can't give you any legal advice. So from sitting on the bench, I can't give you legal advice. There is the Northwest Justice Project. There is Cowlitz County Legal Aid. I don't know where you reside. If you reside outside Cowlitz County, you can contact your local legal aid. But there are services available Mondays and from 12 starting mid-January, Mondays from noon to 2 p.m. There's a free attorney that's here at the courthouse that you can come and talk to. I'm sorry?
Can I bring my little baby with me?
Of course.
Or is that?
Yes, no, it's not in a courtroom. It's just in the lobby in a room off the lobby of the courthouse. So if you need to bring your children, of course, you can bring your children. We'll get all of this process started. I'm gonna ask I'm gonna ask that this be filed, that your information be filed with a cover sheet with the proper cause number on it. So it shows that you filed something, okay, Miss Erickson, because I want to make sure that, you know, you obviously attempted to, but it has the wrong cause number. So I'm gonna ask that they file it with the correct cause number on it.
I accidentally put the protection order cause number, and I apologize for that.
That's
I didn't
okay.
realize.
That's okay. I'm gonna ask that, I don't know if,
how am I gonna
I
see
think
her?
Miss Rosen is probably gonna need to, any counseling sessions that we can set up in the next week or two are probably appropriate. I would like the, exchange to happen if at all possible. So Miss Erickson would, exchange the child with, Mr. Anderson on Sunday, the 24th, no later than,
There's a protection order. Can my dad do it?
6 p.m. Absolutely. Okay, so I want you to have some time on, and if you want to, if the parties agree to a later time on the 24th, that's fine, but the exchange on the 24th. So mom gets Christmas Eve and then dad will have Christmas Day, and then we're going from there, okay?
Your Honor, I just want to say, if she needs help with things that I can help with, I'm totally willing to help her. But I can't help with everything, obviously, but I'm willing to help where I can.
I asked you.
Well, Miss Langford's indicating that she's willing to help you. I don't know. I understand you're frustrated, and I don't understand you don't like the court's decision, but it's time we need to get this sorted out, and you need to follow through with what the court requested of you 2 months ago. So that'll be the order of the court. If it needs to be brought back, any other
get out of it.
presentations, or if it needs to be before me, that'll have to be Fridays come the new year.
All right. Thank you, Your Honor.